Wells, joined by our Vice Chair, Ken Kerr. I know your name. It's Ken Kerr, Delegate Ken Kerr. But no, thank you all for joining us on Thursday, February 19th. We will begin with our first bill hearing, which is Delegate Conway, who is so promptly awaiting our start. So thank you for being on prompt. And we will hear from Delegate Conway, HB 891.
Thank you, Chair. Delegate Conway here to introduce House Bill 0891, Correctional Services, Incarcerated Individuals, Menstrual Hygiene. What this bill does is require the Patuxent Institute in each state and local correctional facility to maintain records on instances of itunes damaged or destroyed due to visible leakage of menstrual discharge under certain circumstances, prohibiting the Patuxent institution in each state and local correctional facility from subjecting female incarcerated individuals to disciplinary measures for items damaged or destroyed without malice intent due to visible leakage of menstrual discharge. What we found out in Judiciary Committee was that in the female facilities, sometimes they limit the health and hygiene products that they give out to the inmates, and therefore, if a person has heavy bleeding or bleeding overnight, they might have leakage on the dead material on their uniforms, and therefore they'll get a ticket for that and disciplinary charge. And we don't think that's right. And we discussed that in my committee, and that's why I put this bill in, to bring it forward to you. And with that, I would answer any questions that I could possibly answer.
Thank you, Delegate.
Thank you. I would hope for a favorable opinion on this bill.
Yes.
Thank you.
I see we have a question from Delegate Crutchfield.
Oh.
Thank you very much, Madam Chair. And Delegate Conaway, can you tell me why you have excluded MCIW, the Maryland Women's Institute, Correctional Institute?
Is that another state or local facility?
It's a state or local, but you've called out Patuxent for some reason, so I'm kind of trying to understand why you...
It said Patuxent and.
Okay.
But the reason why I use Patuxent is because in the testimony that we heard, that was the institution that was talked about.
Okay, got it. And I'm sorry, your indulgence. And do you have data that indicates, you know, that women are being mistreated or disciplined or in any way coming into?
I could forward you the videos from the hearings where the people from Patuxent actually said that they do that. And that's what stimulated me to put this bill in, because they said that sometimes they don't have I get the tampons or whatever to give out, and sometimes the ladies don't have any hygiene materials to use at all. So how is that the people's fault? So that's why Patuxent was specifically named, because they did testify to that.
Okay, and then I have one final question, Madam Chair, and that is, have you been in contact with the ombudsman regarding this at all? I mean, have you heard any complaints? Have they actually complained to her and her staff? And
no, this came about because it came up during testimony in a bill in Judiciary, and then we went into detail about the lack of the supplies, which they admitted to, and therefore I don't think that that's right that someone should get a ticket while they're incarcerated for a natural occurrence that you don't give them supplies to handle that.
okay, all right, thank you.
So I didn't want to go into why the supply is missing and so forth and so on. So hopefully we can quash that before it goes too far.
Okay.
Great, thank you for the question, Delegate. Just trying to see if there's any other questions from the committee. Okay, seeing none, Delegate Conway, thank you very much for your bill. This concludes the bill hearing on HB 891.
Thank you very much, Chair.
Thank you. Have a good afternoon. We'll move next to Delegate Long presenting HB 552. And Delegate Long, do you have a panel and someone with you?
I'm looking around to see if they're here.
Michael Pinard? If not, okay.
We'll proceed.
All right. Good afternoon.
Thank you, Madam Chair and Mr. Vice Chair, distinguished members of the Government Labor and Elections Committee. For the record, I'm Delegate Jeffrey E. Long, Jr., and I am privileged to present to you, but also solemnly, HB 552. On September 21st, 2025, hand in hand, heads bowed, I led the Maryland Black Caucus in prayer as we stood at a long-neglected burial ground of youth who died in a segregated blacks-only youth facility operated by the state of Maryland more than a century ago in my district, District 27B, in Cheltenham, Maryland. The House of Reformation and Instruction for Colored Children was established by the MGA in 1870, 6 years after slavery ended, and 40 years after they passed a law to remove white children from adult incarceration. The House of Reformation formally opened in 1873. Between the House of Reformation's opening in 1873 and 1939, at least 230 boys died while in state custody of the House of Reformation and Instruction for Colored Children. It was not desegregated until 1961 through the work of Juanita Jackson Mitchell, Maryland's first black woman lawyer, and Thurgood Marshall 7 years after Brown versus Board of Education. Let's be very clear, these weren't just any graves. They were neglected children by the state of Maryland. Many were accused of conduct that today would never justify incarceration, vagrancy, incorrigible. And once committed, they were subjected to forced manual labor, harsh discipline, and deplorable living conditions. And that is what happened there. But let me be very clear, Maryland's history is not separate from its present. The story of the House of Reformation is not only about a place, but about systems that treated black children differently and too often failed them while they were in state custody. And while that institution no longer exists, the disparities it represents continue to raise difficult questions about how youth are treated within our justice system today, because Maryland still grapples with auto waiver systems that can result in young people, disproportionately youth of color, into adult facilities more than any other state in the union, second to Alabama. The state assumed responsibility for them in life, and we carry responsibility for them in death. I want to be very clear, though, that this is more than just symbolism, because naming the unnamed is not symbolic. It is an act of accountability, an act of dignity, an act of restoration. Many were buried on state-owned land in unmarked graves. The very few headstones have eroded beyond recognition on the land and in other areas. Graves are marked only by cinder blocks, and for decades, the site was left overgrown and neglected. So what does HB 552 do? It establishes a commission on the House of Reformation and Instruction for Colored Children, chaired by the Attorney General, to direct and oversee an investigation to what occurred at the institution. The commission will be authorized to work with qualified investigators, researchers, and contracted experts to conduct archaeological surveys, forensic analysis, historical research, and meaningful descendant engagement. And through this structure, the commission will ensure access to records, coordinate with state agencies, and examine institutional conditions, policies, and practices that contributed to the deaths of children in state custody. The commission may also facilitate memorialization, dignified reburial processes, educational initiatives, and recommendations for what happened at the watch of the state of Maryland at the House of Reformation, and make sure it becomes a part of shared understanding and accountability. I want to leave you in closing that Governor Moore has already pledged, the BPW has already voted out funding towards restoration efforts, and DGS has secured grant funding for this much-needed work. Those steps matter, but restoration alone does not answer the questions that remain. How did so many children die in state custody? What were the conditions that led to their deaths? Were warning signs ignored? HB 552 ensures that we seek those answers. And that is what happened here. Very clear. Maryland's history is not separate from its present. The story of the House Reformation is not about a place, but about systems that treated black children very unfairly. And so that's why I'm asking you to make sure that we do not undo what happened, but we can commit to uncovering the full truth and ensuring those children are never forgotten again. The time has come to move past prayers, recognition, and healing, but now must be a time of action, a time to reform and restore dignity to a place that has been treated in an undignified manner for so long. And for these reasons, I respectfully urge a favorable report on House Bill 552. Thank you.
Thank you. I see we're joined by someone. I have Michael Pinard on here, but I'm assuming you're speaking in their place?
I'm Betsy Fox Tolentino. Oops.
Okay. Yes.
I'm Betsy Fox Tolentino, Acting Secretary of the Department of Juvenile Services, and here in support of this bill today. And we support the bill as the delegate has intended to amend the bill. And really, we support the core purpose of ensuring a full and public accounting of the children who died while confined at the House of Reformation for Colored Children and acknowledging a painful chapter in Maryland's history. The institution operated during a deeply segregationist period, and investigating its conditions, practices, and deaths is a moral and civic responsibility. Proper memorialization, education, and respectful treatment of the burial sites are essential steps towards accountability and community healing. DJS has started to forward this work, and we are very, very grateful to be able to continue that through the lens of this commission and working with all impacted community stakeholders, families, and young people. Importantly, we have already been able to receive grant funds to help jumpstart this work and are committed to ensuring the grant funds are expended in collaboration and coordination with the commission. We are grateful to be part of this, and thank you, Delegate, for inviting us to testify in support of this bill today.
Thank you, Secretary. Were you pushing it? Oh, yes. Okay. Yep, we're ready for questions. Delegate Sample Hughes.
Thank you, Madam Chair. Thank you, Delegate, for the bill. Thank you for educating us. And thank you, Madam Secretary, for this support that you have for the bill. My question is regarding the fiscal note. So I guess the question is, how did you arrive at the 250? Is it just for the DNA investigation and testing that is done? And how did you come to that as being the basis?
So I'll walk you back, and thank you again for your question, Delegate. So initially, when we were first trying to put together some framework on how we can address what happened, it started really in the summertime with the chair of JPR, Senator Smith, and there were already conversations about the governor's office securing grants through historical trust. I believe I am quoting that accurately. And so the BPW had granted that. You'll see in my version of the bill as it's currently written, it's not reflecting the amendments that I'll be asking the committee to adopt, which will conform this House bill to the Senate version, which now places the Attorney General's office at the helm of the commission, and that thus reduces the fiscal note because they already have the staffing, and they are already in position to be able to carry out the assignment of the commission. But on top of that as well too, with the grant that's been given, it gives us enough of a foundation to get the work going through the commission if passed, to ensure that we can get the necessary funding for the remaining years, because the commission end date is asking for a report by 2029.
Okay. Thank you so much, Delegate.
Thank you.
Thank you very much. Delegate, I wanted to clarify, as I didn't see a letter of support, is this a priority bill for the Legislative Black Caucus?
This is a Black Caucus priority, yes.
You make sure that they send a letter over?
Yes.
Thank you.
Thank you, Madam Chair.
Okay, seeing no more questions on this, thank you very much for this important bill. Thank you, Secretary, for being here today. This concludes the bill hearing for HB 552. We'll now move to HB 1016, Delegate Pruski. Good afternoon. Yes, you may. I have, is that Mr. Brian O'Looney? Is that next? Hi, good afternoon, sir.
Good afternoon. Madam Chair Wells, Vice Chair Kerr, Committee, Good afternoon. I'm Delegate Andrew Pruski here presenting HB 1016, Labor and Employment Non-Compete Conflict of Interest Clauses, Employer Relocation. The purpose of this bill is to add a provision in law to establish that non-competes and conflict of interest clauses are be considered null and void if the employers relocate the majority of the employees or the principal place of business outside the state of Maryland. Currently, there are states that do this already. You look at California, Illinois, Washington, Virginia. I won't go specifically into all those, but they have different means tests in terms of what they used. Why bring the bill? There's consolidation going on everywhere in many different industries. We want to keep skilled workers and professional talent within Maryland's economy rather than having to force to relocate or remain unemployed. We want to prevent out-of-state entities from restricting Maryland workers' ability to pursue comparable employment or establish local businesses. We also want to encourage fair competition, support small business, and benefit Maryland consumers through increased choices and pricing. And we want to strengthen the workforce protections promoting long-term economic growth and development within the state. In simple conclusion, HB 1016 advances Maryland's economic resiliency by safeguarding workers, supporting entrepreneurship, and ensuring that restrictive employment agreements can't undermine the state's labor market after employer departs. This is a policy decision that we hope will be enacted in Maryland, and I thank you for your time and consideration and ask for a favorable report for HB 1016. I do have a witness that will present today on why the bill is important. Thank you.
Good afternoon, Madam Chair Wells, members of the committee. I'm here to support the limited non-compete reform bill, HB 1016, currently before you. As you may know, Maryland's existing non-compete protections apply only to certain medical professionals, veterinarians, and individuals earning approximately $50,000 or less. The gap is becoming a significant concern within the construction industry, where consolidation by out-of-state entities is constraining opportunities for local professionals and tradespeople, reducing the available contractor pool, particularly in the architecture, civil engineering, plumbing, and HVAC professions, and ultimately increasing the cost of building across the state. Many affected workers are also unable to speak publicly due to non-disclosure agreements layered on top of the non-compete provisions. This bill would promote economic freedom for Maryland workers, reward employers who maintain jobs and operations within the state, and strengthen Maryland's innovation economy. The legislation helps retain skilled workers and professional talent within Maryland rather than forcing relocation or unemployment. It prevents out-of-state entities from restricting Maryland's workers' ability to pursue comparable employment or establish competing local businesses, encourages fair competition, supports small business formation, and benefits consumers through increased choice and competitive pricing. Importantly, the bill does not restrict Maryland-based employers from using reasonable non-compete agreements. Instead, it applies only in circumstances where out-of-state entities control, limits the economic mobility and opportunity of those living, working, and investing in Maryland. In doing so, HB 1016 strengthens workforce protections while promoting long-term economic growth and positioning Maryland as a welcoming destination for entrepreneurs constrained by overly restrictive non-compete agreements elsewhere. Thank you.
Thank you very much. Just seeing if there's any questions for the sponsor or the sponsor panel. Okay, seeing none, thank you, Delegate Pruski.
Thank you.
We'll move, we do have one unfavorable in person, Grayson Wiggins. Good afternoon.
Good afternoon, Madam Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. We support Maryland businesses, obviously, with the Maryland Chamber of Commerce. But the language in the bill is perplexing and concerning to us. So you've got a threshold that voids non-compete clauses if more than the majority of 30 employees are relocated across state lines. I heard the discussion about California. We're not California. We are, a very transient state. You can be in 4 different states. If you drive 3 hours north of here, my understanding is that people in Maryland, we all live within an hour of another state. And so the concern that we have is that you may have an employer who is a Maryland company who has, for numbers' sake, has 30 employees in northern Maryland. And some of them, 14 of the employees are located in Pennsylvania, 16 are located in Maryland. If they relocate one employee to Pennsylvania at any time, then it voids all the non-compete provisions in the bill or in the contract. And my understanding is that there are already protections in place related to non-compete contracts like time, place, and manner. And so I think just the general logistics of the bill are what concern us the most, given the number of employee threshold and the timing of it, which is provision B in the bill. Thank you, Madam Chair.
Thank you very much. All right, it's lighting up. Delegate Ruth.
Thank you, Madam Chair. Mr. Wiggins, thank you. Just a quick question. Some of your concerns seem to be about the language, but you're unfavorable. Are you open to discussing amendments with the sponsor that might tighten the language up and make it more fair for Maryland businesses?
Absolutely. We're always welcome conversation on amendments on any bill.
Thank you.
Delegate Wilson.
Thank you, Madam Chair. Grayson, I don't want to put you on the spot, but I guess, so just when we talk about non-compete clauses with the Chamber of Commerce, what percentage of employees do you think this affects? And if you don't know, do you have an idea?
Throughout the state?
Yeah.
I don't have a percentage number for you.
Does it seem it's something that's normally used in most businesses?
I think it's used.
And I'm not trying to put you, I guess what.
Pretty commonly. I don't have a percentage, but I think it's a regularly used option for businesses.
I would hope it's not overly used because, again, a lot of times as we find out it's almost pointless. That's why I didn't think this was affecting that many people. But I guess picking back off what Delegate Ruth said, are you not supportive of the idea, or is it the language that I don't want to say offends that you have a problem with?
I'm always concerned about the language. I mean, I think the issue here is, and my understanding to your point is that there are already protections in place on when a non-compete clause can be enforced. And so for us, it's almost like a gotcha provision in the bill, because it's any time a majority of your employees aren't located in the state, then it voids the non-compete clause. And it doesn't define location. So if I'm an employer in Northern Maryland and I have, again, 16 in Maryland and 14 in Pennsylvania, and I relocate one to a job site in Pennsylvania, now I have, 16 or 15 and 15, or 16 and 14. That just, why? What's the public policy behind that, I guess?
And that's what I was trying to get to. And I guess, as far as working, with the bill, it was just the overall bill itself that offended you, I see the policy, or was it specific language? And only because, a lot of times Madam Chair may not want to spin her wheels trying to solve a problem that can't be solved. So if there's a resolution, but if you're just saying generally behind the policy, you think the policy is redundant?
I think I don't see it necessary the way they've structured it here with the 30 employees and the math on it, because again, we have companies who are based in Maryland, and the location is not defined in the bill that I see.
Right. And you believe there's enough protections when it comes to
I do, yeah.
Okay, I just was wondering. Thank you.
Thank you. Delegate. Double checking. Seeing no more questions from the committee, that concludes the bill hearing for HB 1016. Thank you very much. We'll move next to House Bill 69, Delegate Vogel.
Madam Chair, Mr. Vice Chair, committee members, I will start with some bad news. This is my last day before this committee, this session. I know you all will miss me very much.
A momentary moment of silence. Momentary moment of silence.
It's been a great few weeks on like 10 bills, but here with House Bill 69. During the last federal administration, there was a federal rule set forward by the Department of Labor that raised the threshold for which salaried employees can qualify for overtime pay. Right now, that threshold is approximately $35,000. So any workers who are, most workers who are making over $35,000 a year in their salary do not qualify for overtime pay. That equates to about $17 an hour. So what we're seeing is workers being classified as salaried employees, as managers to avoid having to pay them overtime compensation. What this bill does, I got to thank the Chairman Emeritus of the Economic Matters Committee. The bill was moved out of ECM last year. It did have a bit of a holdup on the floor, in part because the bill as it was drafted last year increased that threshold immediately to about $55,000. The way the bill is drafted this year, it has gradual increases of $3,000 a year up to $50,000 in 2031. I don't know if I mentioned this, but the federal rule was struck down by a federal judge in Texas. It is my view that the wages of Marylanders shouldn't be determined by a judge in Texas. There are about 80,000 workers in our state, salaried workers, who would see one of three things if this bill were to pass. Number one, their salaries would increase. Employers have the ability to increase their salaries above the threshold and still not have to pay overtime. The second option is that employers would be required to start paying overtime for work above 40 hours a week. Or the third is that those workers could be reclassified as hourly employees and fairly paid for the work that they are doing. So with that, I urge a favorable report on House Bill 69 and happy to take any questions.
Thank you, Delegate. Just seeing if we have any questions from the committee. I do not see any questions from the committee, so thank you very much. We'll move on next to the unfavorable testimony. Mr. Mike O'Halloran.
Good afternoon, Madam Chair, members of the House Government, Labor, and Elections Committee. For the record, my name is Mike O'Halloran. I'm here today representing NFIB in Maryland. You have my written testimony in front of you. If you care to follow along, I'll try and summarize some of the points in that. Basically what this bill would do is it creates a nearly 45% increase to small businesses when it's fully implemented. I understand the difference between last year's bill to this year's bill is it's actually graduated over a number of years. But for small businesses, I guess, what I should have done is started with some good news and that I point out in the written testimony. The good news is that 30% of small business owners reported raising compensation in January. That's actually up a point from December. So while small businesses in Maryland may not be raising compensation to the degree that the sponsor would like to see, the fact is we're trying to do what we can with what we have. So passing House Bill 69 would kind of blow those budgets to the side and really put small businesses in a tight spot. So for that reason, Madam Chair, we do respectfully request an unfavorable report on House Bill 69.
Thank you very much. All right. Oh, Delegate Fisher.
How are you doing, Mr.
I'm doing well, sir. How are you?
Good, thank you. Is one way maybe to increase pay for overtime to maybe just not tax overtime?
I mean, that's an interesting thought. I know, obviously with some of the federal action when it relates to tips, I guess short answer is it could be possible. I don't know. But I think the worry there would be the employer still paying that overtime, I think would be the concern.
Sure. I guess my point is that it seems like one way of plussing up an employee's pay is to take less of the employee's income through taxes. It's really just kind of a principle that kind of makes sense, rather than trying to micromanage what the small business community does or doesn't do. Does that make sense?
It makes sense. I'm more worried about what Delegate Wilson is now going to chime in with because of your question. But no, look, I certainly, from a small business owner's perspective, I think we always encourage ways to save not just employers but employees money as well. But I think to your point, I think the worry is that the overtime would still be coming out of the business.
Sure. I mean, and the other question is while the bill may or may not apply to restaurants and folks who make tips or what have you. I mean, we've seen a lot of bills that eventually will in Annapolis, again and again and again, that attempt to pay tipped wages and increase the wages to $20 an hour or what have you, which would literally wreck the restaurant business. And that's why I say this. It just seems like maybe if we just stop taxing people so much to begin with,
Sure.
they'd have more money in their pockets rather than giving it to the state, as opposed to telling the business community that they're the problem. Because I think the issue is, and isn't that so? I think the issue is that that the government is the problem. They're actually taking too much of people's money to begin with. Isn't that so? Thank you.
Thank you very much for the isn't that so. I love it, isn't that so? Delegate Wilson.
Thank you, Mr. Holloman. It's parliamentarian. I'm
Oh, yeah. I heard Chair Emeritus.
Right. No, so, and I guess the issue that I think we discussed in years past is an individual making roughly $17 an hour, especially in this current job market. Unlike, I think when the inception of this bill, we had a good economy. Something happened last year that kind of changed that. But the labor market is drastically different. We've lost over 1 million jobs this year, so people are more inclined to take less in order to just maintain their livelihood and their family. The concern is, I believe, is there a limit, do you believe, of when a person can't be, has to be paid overtime? Like if it's $17 an hour, you don't agree with that. So basically, you're saying that if you make $17 or $18 an hour, I should be able to lock you into a job that I can make you work as many hours as I want. That sounds like, and again, I'm not trying to put words in your mouth. What's the line? At what point do you think people should be getting paid for the hours they work? Is it just at minimum wage?
Sure. I think the simple answer is it all depends on what the employer, what the job is, what's included. I mean, I understand you're not trying to put words in my mouth, but I think, the idea that an employee would be locked in to a job, I think the good news is, in addition to small businesses raising wages for their employees, they're also trying to hire. And that also creates an upward pressure, a market-based upward pressure to raise wages. I suppose a counter argument to that would be like, well, would this really cause an issue? I think it would cause an issue for, some small businesses that maybe can't afford what this bill seeks to do.
I think I disagree, and I don't want to go back and forth on your premise because we've lost over 1 million jobs this year. The hiring has been, the labor market has actually been devastated. So I do believe at this point that the employee is put at a disadvantage. Whereas before we were talking, I would have agreed with you in past. Mm-hmm. But the labor market has flipped up. The amount of jobs we've lost, in Maryland included. So I do believe that the employee is now at a distinct disadvantage. And I was just saying, I just don't know if shouldn't there be a line of when a person gets paid for their work? Because if you think, I guess your logic is that you're not locked into a job. I disagree. I think that's just simply untrue. Right now, there are more people looking for work than there are jobs. It was different when we talked last year. Mm-hmm. But I think it's changed dramatically. And so my fear is that the way the standard currently is, if you make basically $17 or $18 an hour that I can make, that's how you think it should stay.
I think I'll go back to my previous answer. I think employers are going to compete for employees. They're going to pay what they can to the employee. I don't know, you're asking me, what should that level be? I can't give you a dollar amount. Certainly what's in statute right now when it comes to overtime, those that do qualify for overtime, they're making time and a half. The salary threshold, I'd have to stick to my answer of, employers are going to do what they can to keep qualified employees. And they're going to try and pay what they can to attract those employees. As far as business openings in the job market, when I say that small businesses are trying to hire, I'm just going by, what our surveys tell us when we survey our members, what they're telling us, and they're saying that they have job openings. Admittedly, some of them they just can't fill, and that's for a variety of reasons, not least of which is, not finding the skilled workforce.
Okay, and I don't want to belabor. I hope you do understand that the policy behind this is just, in tough job times when people are not leaving their jobs and they're being asked to be more productive for the same amount of money. And a lot of times that means working more hours and getting less remuneration. And that was the concern I believe that we were trying to address. But I appreciate your input. Thank you.
Sure.
Thank you very much. Delegate Chisholm.
Thank you, Madam Chair. I know you're the expert on this. Where does Maryland rank in business friendliness?
I believe, if I'm looking at my written testimony, business friendliness, I want to say there was a ranking that had us 47th. There was another ranking that had Maryland ranked as second from the bottom in terms of starting a business. I think that was, if you're talking about rankings, that's what my memory, whatever it is, that's where my memory takes me.
And looking at the national landscape, do we know what the year-over-year increase in average hourly wages have been for the last 12 months?
Sorry, could you repeat that?
Do you know what the average hourly wage increase has been throughout the nation in the last 12 months?
I don't know that off the top of my head, no.
It's 3.7%. And do you know how many jobs we added in January?
Ooh, I don't know that off the top of my head.
130,000. The reason I asked the question is I feel like when I look at a bill like this, are we actually helping to make the state more business friendly, or are we making it more hostile? And based on all those figures I just gave you, especially compared to the rest of the United States, do you feel like this is going to be looked at as more business friendly that then encourages more hiring and more job creation, or do you think it does the opposite?
Sure. I mean, look, I would draw from the state's the bill's fiscal note under the small business impact. It would certainly drive up costs, and when you drive up costs, that in turn kind of makes Maryland less competitive.
Okay. Thank you, Madam Chair.
Thank you. Delegate Fair.
Thank you, Madam Chair. Thank you so much for your testimony today. I ran a small business for 20 years in Frederick, and I just want to posit a story to you and then kind of bounce off of that story to bounce off of some of, I think, what Delegate Wilson was talking about. So in 2007, the city of Frederick brought into downtown its first Starbucks location. It was a big deal because there were no national brands in the downtown business climate. We were very focused on independent small businesses, mom and pop shops. And so there was a huge fervor around Frederick over the fact that a Starbucks was going downtown, as all of the mom and pop coffee shops thought that they were about to go under because they were going to get pushed out by the big giant conglomerate. We actually saw was that suddenly all of the coffee shops felt the need to compete in the same space, and most importantly, they found the need to compete in employment in the same space. And so what we saw all the mom and pop shops kind of band together to work with one another to increase their service model, to make sure their service model was more in alignment with where the current trends in coffee shops were moving. And then we also saw something very interesting. Suddenly pay for baristas started going up across the board because Starbucks was actually paying their employees a little bit more than most of your local coffee shops were already paying. And what we didn't see was any of them close. And so I posit that story as to preface my question, which is when you're concerned about labor constantly being undercut by people trying to get the most out of the smallest amount of money, isn't it possible that possibly when we look at something like this, that it helps for businesses to then increase the pay across the board for those employees that exist to be able to compete in the market instead of just trying to undercut the labor market constantly. Rather, they compete with one another to create that capitalist market to then actually uplift employees in the process instead of trying to figure out how to shove the employees down to the lowest common denominator.
Sure. I think I think our members would agree with you that the competition is good. What I didn't hear, about the circumstances in Frederick, it sounds to me like that was private sector driven.
Yeah.
That they were competing. This, I think, would otherwise be, a mandated approach to pay.
Of course, because if everybody in the sector says, okay, if we all keep wages as low as humanly possible, and we're not paying our employees a livable wage, then everybody's going to stay there and be happy with that solution, right? However, if some kind of market force changes that, whether that be a mandate from the government or whether that be a national chain coming in, suddenly that upends the status quo and says, okay, we have to reevaluate our process by which we're paying our employees. Is that fair? Do you think that's fair?
I think if given the choice, I think businesses in general would prefer the private, the market-driven approach as opposed to, let's say, a government mandate.
Sure.
Because a government approach, or a market approach, it sounds like all of these other, independently owned coffee shops were able to maintain and make some adjustments. I'm sure it wasn't easy for all of them. I'm sure maybe a couple of them were close to closing their doors, but I guess if given the choice, and polled members, I have to believe that they would probably come back and say we'd rather take our chances with a market-driven approach as opposed to a government-mandated approach.
Sure, but to be clear, we're in agreement that the market forces can change depending on what the status quo is and what is the new force coming down on the marketplace. We agree that is the thing that changes how we pay employees and what benefits we provide and how we compete in this capitalist society, whether that be government or private market.
I think, look, I don't have a degree in economics, but I'd agree with you that, there are all sorts of things that go into whether or not a business is successful.
Mm-hmm.
And certainly market pressures are part of that, for sure.
Yeah. Okay. Thank you. Thank you, Madam Chair.
Thank you. Delegate Fisher, who has an economics degree.
Sorry?
Do you have an economics degree?
Yeah, well, international economics, but, so, yes. So I guess my question is, and that all sounded great, and I do appreciate the comments from my friend from Frederick. But we don't live in an island in Maryland, right? Companies can leave, many companies can leave on a dime, especially companies that don't have bricks and mortar, that are in the consulting business or, all kinds of different businesses. Isn't that correct?
That is correct.
Right. And isn't it indeed the case that that is actually what is happening? That we have a net loss, out migration of citizens from Maryland to other states that are much more friendly to taxation of individuals and taxation of businesses. Isn't that correct?
I believe I did see, I believe it was the comptroller's report that indicated that there was a net, using my terms correctly, out migration.
Yes. And so the ultimate poll for whether a state is working for its people or for businesses is whether or not people want to stay. And they don't. And I think this is an important conversation because it's going to be a theme this entire session that I look forward to speaking about. And I can't tell you, and hopefully you've been there. Have you been to Austin, Texas? Have you been there? Have you seen what's happening there?
For a bachelor party one time, if we're being fully transparent.
It's a great party.
That was about the only time I've been to Austin.
You don't remember remember when you were there. But the fact of the matter is it's a booming town, and the tech sector is moving there because of its geographical location to California, where people can't wait to leave. And Maryland, I think, has a similar economy. Colorado does too. Palantir just left, just announced yesterday. So fact of the matter is, again, it's semi-question, but I appreciate that you come here and you describe why these aren't pro-business, and isn't that so? Thank you.
Thank you very much. Okay, seeing no more questions. Delegate Tomlinson, Delegate Tomlinson.
Thank you, Madam Chair. I just wanted to follow up about the bachelor party.
Fair enough.
All right.
What happens in Austin stays in Austin, I've heard.
Not now, it's on the record.
Fair enough. Thank you, Madam
All
Chair.
right, thank you so much. That concludes the bill hearing for HB 69. We will now move on to our final Vogel bill of the year. HB 45. And Delegate, I believe you have a sponsor panel, is that correct?
Yep, they're coming up.
Okay, thank you.
Thank you, Madam Chair. Madam Chair, Mr. Vice Chair, here with House Bill 45, the Maryland Worker Freedom Act, which restricts captive audience meetings in the state of Maryland. I have a phenomenal panel. I'll let them go into the details here. Captive audience meetings are meetings where workers are held in a room and a certain agenda is pushed on them. That agenda can be religious, that agenda can be political, or that agenda can be focused on busting a union. I think it is wrong for an employer who, say is a Democrat, to force every worker that works for them to sit in a room and talk to them about why the Democratic Party is right on certain issues. That has nothing to do with their job, nothing to do with what they're required to do at work. I think it is wrong for an employer of a certain religion to force every worker that works for them to sit in a room and listen to why, to them speak about their own religious beliefs when that has nothing to do with their employment. This bill passed out of the Economic Matters Committee last year. It passed out of the House. There were some challenges in the Senate and some concerns around the need for further exemptions. Those exemptions were amended in, and now they are in this bill this year. So many of the concerns that I know that the Chamber of Commerce had raised last year have been addressed in this bill as it stands right now. I urge a favorable report on House Bill 45, and I will turn it over to Donna.
No, that's
Kayla?
good.
I was going to yield to the worker first.
Nicole, go ahead.
Yeah, just throw me under the bus.
Nope, you're good. You're doing great.
Good afternoon, Vice Chair Kerr and other members of the committee. My name is Nicole Jones. I'm a registered nurse with the medical vendor Centurion at Western Correctional Institution. I've worked as an RN and LPN for over 10 years, and my past medical experience includes working at NBCI, RCI, and MCTC. I love what I do. People who are housed in our facilities deserve to be treated with respect and dignity, and they deserve quality medical care. While I'm passionate about my work, it comes to no surprise that my job can be extremely stressful. The workload on my coworkers and I is incredibly demanding. Oftentimes, I'm texted by management in the early hours of the morning, notifying me of changes to my workload for the day's shift. We are understaffed, and on the weekend shifts, there is one nurse for the entire compound, which means one nurse for over 1,000 incarcerated individuals. Due to these working conditions, my coworkers and I have decided to form a union with ASFME. As we started forming our union, it became clear that our employer was opposed to our union. My employer sent out multiple text messages, emails, and discouraging us from organizing. Additionally, during my scheduled work shift, I was pulled into a room where an outside vendor hired by Centurion gave me a 30-minute lecture as to why we should not unionize. Again, this occurred during my work shift when I was trying to collect sick call passes, which are important to collect to identify the potential medical needs of the people in our facilities. Centurion also flew out top executives and lawyers from the company and held group meetings with all of us employees to discourage us from unionizing. My coworkers and I were scared to speak up for fear of losing our jobs. For months, we were filled with anxiety, wondering what would happen to us if our employers supported our union.
Good afternoon, Chair, members of the committee. My name is Kayla Mock, and I'm here on behalf of over 10,000 members of the United Food and Commercial Workers Union, Local 400. I'm also here today on behalf of the workers who have seen be impacted by mandatory captive audience meetings. My first role at Local 400 was as an organizer, and so it was my job to walk workers through the process when they reached out about how to organize a union. And I saw the impact that mandatory captive audience meetings had on workers just trying to organize. When I would warn workers about captive audience meetings, they would always ask, do we have to go? And I would tell them, yes, if they make it mandatory, which most do, and they're used in over 90% of organizing drives, then you have to attend. I would stress to them that as an at-will employee and as workers without a contract are, that if they refuse to attend a meeting, even if it has nothing to do with workplace instruction, they could be disciplined or terminated. I want to uplift one account of workers organizing and the captive audience meetings that they faced. A group of produce truck drivers began to organize their union. When the boss found out, they hired 2 consultants to hold captive audience meetings. They decided to split the workers into 2 groups for these meetings, and they split them by race. And so they put all of the African American drivers into one meeting and all of the Latino drivers into another. And in the consultants in the meeting with the African American drivers told them, oh, you don't need the union. It's only for the Latino workers who are illegal and don't speak English and don't know their rights. And in the other meeting with the Latino workers, they told them, you are hard workers, you don't need this, it's just for the lazy workers in the other meeting. The workers were furious, they were very close, and that they had to sit through these meetings every day because they were required by the boss, and they had to hear what their boss had to say about them, and they could not refuse to go. No worker should have to go through this, which is why we urge a favorable report.
Good afternoon. I'm Donna Edwards. I'm president of the Maryland State and DC AFL-CIO, and on behalf of over 700 affiliated locals with our state fed, I'm here to say, please give a favorable report to Senate Bill 45. A person has all the right in the world to express their views and how they feel about it, but they don't have the right to put their views on people who don't want to listen. The First Amendment permits the protection of the unwilling listener. This bill is not about labor relationships. This bill is about coercion of workers. There have been many cases filed in the 13 states that have already passed this. I want to lift up that as of Friday the 13th, Connecticut did go through court, and that law is going to be enacted. I can send you the podcast from their Attorney General. You may hear that it still is in court, but it's settled by now. There was a challenge to the Illinois law, and it was dismissed by the court. And there was a challenge to the Minnesota law. It was dismissed by procedural grounds. In California, there is still preliminary, there was a preliminary injunction, but they're waiting on the plaintiffs to provide a merit to the case. Like I said, the Connecticut law has been settled, and the 2 challenges in Oregon law were also reached because of merits. This stands because it does not encroach anybody's freedom of speech. It is not about freedom of speech. You are allowed to talk about whatever you want. You can ask your employees to come. What it protects is that employee that does not want to listen to your views, whether they're political or religious or your feeling about the union. We think that even people who may have an employer that likes the union, that wants to talk about the union, they have a right not to listen to saying that you need to join the union. This is about freedom of the willing to listen, not about taking away anybody's freedom of speech. So with that, please give it a favorable report. Thank you.
Thank you very much. Delegate Ruth.
Thank you, Madam Chair. Thank you, Delegate Vogel. Just first of all, a quick question. I believe you said this, but I just wanted to confirm that the bill that you've introduced this year is the same one that passed the House last year. Is that correct?
Thank you, Delegate. For the most part, yes. What we added onto it were a few exemptions. For example, government relations professionals, if they have to discuss policy for work, that's acceptable.
Okay, thank you. And President Edwards, you listed those cases very rapidly, and I believe your intent was to, and I wonder if you could talk a little bit more, that these cases show that it's not a violation, that it's not a violation of the First Amendment to prohibit these employers from keeping people captive?
It has found that there is not a violation of the First Amendment. In Connecticut, where you will hear maybe from opposition that they say that the Department of Labor said that they will not pursue any charges or anything against the Connecticut Business Association. Well, the reason being is that the Connecticut Business Association's work is lobbying. So as is the amendments to this bill, if that is part of your work, then obviously you have to talk about the positions of legislation and how you feel because you're an advocacy group. So, but otherwise, no, it does not encroach. You can still talk about and say to your employees, please come to this meeting, but an employee will not be retaliated against if they don't want to hear it. And in this very divisive political climate, it's getting more, it's so much less about unionizing and so much more about political candidates and political ideology than it is that workers just don't want to hear.
Thank you.
Thank you. Delegate Sample Hughes.
Thank you, Madam Chair. Thank you, Delegate, for the bill. I wanted to ask the young lady on the end, my apologies, I can't recall your name.
Nicole.
Nicole, thank you for your testimony. Within your testimony, I just had two questions for you. What is the mandatory, based on the Correctional Standards Commission, what is the mandatory number of inmates you're supposed to have to your position as being a nurse?
The ratio?
Yes, the ratio.
There isn't
yes.
one.
There isn't? Oh, okay. And were you ever able to form the group that you were trying to form to discuss these matters?
We are currently still in the process of trying to unionize. My company, Centurion, has red taped us to the point where we've been trying to unionize we did our vote over 4 months ago and we still aren't unionized. But we do have a hearing, I think, scheduled in about 3 weeks that we finally got. So we're hoping to fix that soon.
And last question, within that meeting that you're trying to bring together everyone, are you advocating for there to be a minimum number of inmates, that ratio for
yes,
your position?
We are. One of the things that we're hoping to discuss is workload and the ratio between how many nurses there are versus, you know, if we have a fight and there's 5 people involved, we've got 5 injured people and 1 nurse. So we're trying to work. That was part of why we wanted the union, was to fight for that.
Sure. Okay. Thank you. Thank you so much.
Thank you very much. Okay, seeing no more questions from the committee, thank you to the bill sponsor, to the sponsor panel. We'll move on next to our unfavorable testimony.
Thank you.
Thank you, guys. We have Philip Missamara, Kaylee Locklear, and Grayson Wiggins.
Good afternoon, honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are respectfully here in opposition. Labor relations in the United States are governed by the National Labor Relations Act and enforced by the National Labor Relations Board. Federal law prohibits and protects an employer's right to express views, arguments, and opinions about unionization. This bill would prohibit mandatory employer meetings on union issues, speech that federal law expressly protects. This policy judgment would be contrary to the balance created by the NLRA, which protects the right of employees to support and join a union and the right to refrain from any and all such activities. For that reason, similar laws are already being challenged in federal court. In a recent California challenge to their law, the court granted a preliminary injunction determining that the NLRA does preempt the law and that it violates the First Amendment. Beyond preemption, restricting employer meetings raises serious First Amendment concerns. The government should not silence one side of a workplace debate, and this bill stemmed from the belief that union membership should be encouraged by preventing employees from getting information that might convince them not to join or support a labor organization. Banning so-called captive audience meetings does not empower workers. It limits their ability to hear information and ask questions about union representation, dues, and workplace impacts. As an expert witness, we have invited Phil Miskamara here, who is the former chair of the National Labor Relations Board. We do urge an unfavorable report, and I'm glad to answer any questions that the committee has. Thank you.
Chair Wells, Vice Chair Kerr, and committee members, my name is Philip Miskamara. I'm a law partner at Morgan Lewis Bacchius, and I previously served as chairman and a board member on the National Labor Relations Board. I'm also a Maryland resident, and the Maryland Retailers Alliance asked me to testify today. For 3 reasons, I respectfully oppose House Bill 45. First, the bill's mandatory meeting restrictions prevent employers from expressing an opinion about unions. This will create multiple track state and federal litigation because these issues are heavily regulated by federal law. Second, I believe the courts will find that the bill is preempted by the National Labor Relations Act. Third, I believe courts will find that HB 45 violates First Amendment free speech. I'll end by mentioning another House member, John F. Kennedy, who addressed these issues. President Kennedy spent 6 years in the U.S. House of Representatives and 7 years in the U.S. Senate. During his first year in the House, President Kennedy wrote that employers must have, quote, the same rights of freedom of expression as everyone else. As a senator, he emphasized the importance of union election campaigns where, quote, both parties can present their viewpoints. President Kennedy was one of the nation's most passionate labor and employee advocates, but he defended everyone's right to express their opinion about labor issues. I encourage this committee to do the same thing, which warrants an unfavorable report on House Bill 45. Thank you, and I welcome the committee's questions.
Thank you, Madam Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. I echo my colleagues' concerns. I'm just going to put a few finer points on things, and I'm going to focus on one specific provision in the bill, or section of the bill. So first, as was mentioned previously, there is an injunction on the California law. It was issued in the Ninth Circuit by a judge appointed by President Joe Biden. That case is still pending. The Connecticut case was dismissed. My understanding is it's more of an issue of standing, and actually came down to it in part because Connecticut indicated they never intended to enforce the law. So just consider that when you consider these cases that are being talked about. Down to the bill, page 2, lines 3 through 9. What this bill is doing is it's prohibiting an employer from holding a meeting or requiring people to attend a meeting to discuss potential changes in public policy. We've talked a lot in this body, and I listen to the House floor all the time, and there's a lot of discussion about the changes at the federal level that are negatively impacting Maryland. Those changes negatively impact businesses, and businesses should be able to require employees to attend meetings to discuss potential changes to public policy, not only from a market perspective, but also as it pertains to immigration issues. So the Maryland Chamber of Commerce, we just had an immigration webinar for our businesses because many of their employees are worried about the changes in immigration enforcement. This bill, as I read it, would prohibit an employer from bringing their employees together to talk about changes in immigration enforcement and to talk about changes to other policies that impact their ability to operate, their ability to employ people, and given the consistent and volatile nature of the changes at the federal level, we are very concerned that businesses would be unable to do that. For those reasons, we are concerned and opposed to the bill. Thank you, Madam Chair.
Thank you very much. Delegate Wilson.
I don't have to do anything. This is for anyone who wishes to answer. So first, because I'm trying to understand the First Amendment issue, because from what I'm reading, it does not stop employers from setting up these meetings. It just doesn't allow them to punish people that don't want to attend. Am I correct?
So the way I would view that is I'm a government affairs employee. So my employer pays me to advocate on a potential public policy change.
Right.
If this bill were enacted as it is, my employer could not require me to attend any meetings.
But Section D, line 3, or I'm sorry, Part 3 says, does not prohibit employer from communicating to its employees about information that is necessary for its employees to perform their duties.
I would argue that it needs to be clarified because this was a question that was raised on the Senate floor last year very specifically as the bill was introduced and is it reintroduced this year. And we are under the impression and the interpretation that was given on the Senate side was that it would not apply in that situation.
That was last year's bill. These are the exceptions that were now added. So, because I'm looking at the exceptions, communicating things required by law, involves religious matters or political if attendance is voluntary, institutions of higher agents. Okay, I don't want to go through them all because there's a gang of them. So I hope, because I didn't understand the First Amendment violation when, again, you're allowed your right of free speech. You just can't mandate anybody listen. You right now have a First Amendment right to speak.
Correct.
We cannot stop you. I can walk out and I can't be punished. So that, I believe that was the intent of the bill. Now, I'm reading through it. It doesn't seem like it's changed, but I want to go back more importantly. I was reading a decision, November 13th, 2024, the Amazon decision, which ruled that the employer violated the NLRA by requiring employees under threat of discipline or discharge to attend meetings in which the employer expressed its own views on unionization. That is established case law. And that was, again, the Amazon Services LLC, November 13th, 2024. Now, I know that the NLRB has since changed since 2025, and maybe there's some hopes this will be overturned, but at this point, that's established case law. So in the face of that, I don't understand how this bill is offensive because we already have case law saying that they can do it. And again, they put on exceptions because I think that they were listening. And this is for anyone who wants to chime in, by the way, because explain to me what I'm missing because the case law says something else.
Yeah, two responses, Delegate, and I appreciate the question. One is, under federal law, if the National Labor Relations Act either prohibits something or protects something, it's preempted either way. So the fact that the NLRB has ruled that mandatory meetings, like what you described, are unlawful, that actually establishes that state action in this area is preempted. And the second response is that the NLRB has come down both ways. In 1948, the NLRB ruled that employers have a First Amendment right to conduct these types of meetings, and that was exactly for 50 or 60 years.
Right.
And the NLRB in 2024 or 2025 in the Amazon case found that those meetings are unlawful, but the NLRB does not get the last word when it comes to First Amendment issues. And that case is currently on appeal.
And I don't disagree, and I guess I'm just trying to understand what, so you disagree, basically everybody at the table disagrees with the NLRB's holding about how the NLRA applies to this issue.
I disagree with that case, and especially disagree with the board's treatment of the First Amendment in that case, which is on appeal.
And again, your thought process is that as an employer, I can mandate my paralegals to come in and listen to anything I choose to espouse because they're being paid hourly.
Yes, and there are all kinds of necessary meetings associated with the employment relationship. And to answer your other question, which is a very understandable question, although the bill, HB 45, indicates that voluntary meetings are permissible, under the First Amendment, if any law singles out speech on the basis of what's discussed, content, or singles out particular types of speech based on who the speaker is.
Like hate
in this case, employers.
Or like hate speech, right?
Well,
that's
yes.
illegal, but that is illegal, right?
But that's the basis for the finding that in this bill, it would infringe upon the First Amendment, even though the bill does have an exception that relates to voluntary meetings.
So I guess, because I really thought the exceptions cleared up everything you discussed. But again, there are forms of speech that are not protected. And I think the NLRB has already come out with their holding. Again, of course, I guess I see that, it's still alive, but I was trying to find out the First Amendment because, again, it wasn't requiring anybody to stop speaking. It was just requiring, it didn't force me to listen. And that's why I don't understand the First Amendment and how you think we're trampling on someone's First Amendment rights when you can still say everything you want to say, but your employees can just go back to their desk and do their work if they choose not to listen when it comes to political and religious views. And then we made the exception. So what are we missing?
Well, the one thing I'll just add, Delegate, is a near identical law in California was also found to violate the First Amendment. And I'm counsel in the Connecticut case that was decided last Friday. And in the Connecticut case, the district court actually agreed with the California case and said that the California court's finding that these types of laws violate the First Amendment. In the Connecticut case, the court said that the California finding of unconstitutionality was, quote, thorough and well-reasoned.
What's that? Could you give me I want to look the case up. What is the case that you're talking about in Connecticut?
Yes, that's the Connecticut case that was decided last Friday.
Do you have the case number?
It's in my written testimony.
Okay, I'll find it.
Yes.
But you will also agree, just by that statement, they didn't say that the California case was moot because the NLRB had made a decision, correct?
They did not address specifically the NLRB case, but again, the NLRB has come down both ways with respect to the First Amendment issue.
I'm just saying, because before you stated that you didn't think that this body even had a right to do that because the NLRB, it's within their purview. But that's not what the Connecticut court said, is it?
Well, the Connecticut court didn't address the issue because the Connecticut court found there was no standing because the Department of Labor indicated that it was not going to enforce the law against the principal plaintiff, which was the Connecticut Business and Industry Association. But the one other point I'll make is the Connecticut case has not been settled. In fact, the court has scheduled a hearing for March 12th to discuss the path forward in the case.
Right.
So that case remains ongoing at the present time.
I was just interested in what the legal justification was because it's, from the research I've done, it differs, but thank you very much.
Sure, thank you.
Sorry, Madam Chair, for taking so much time.
It's okay. I don't think she wants us to make a big fanfare of it, but I did want to acknowledge that we are joined today by the speaker, Jocelyn Peña-Melnick. With that, I'll move to our next question, Delegate Terraza. Oh.
Yeah. Thank you, Madam Chair. I think most of my questions were asked by Delegate Wilson. I was reading that same section D on page 3, and I don't understand how this is limiting any information. Ms. Locklear, I don't understand how this is limiting any information that the employees might want to get. It just says that it has to be voluntary, just like the union can't, or other employees can't require other employees to attend a meeting and listen. It seems like the same thing. You can't, as long as attendance and participation are voluntary.
Yeah, I think to your question, as it pertains to what I was referencing, which is the changes and proposed changes to public policy, is that our position is that an employer should be able to require their employees to attend a meeting if, let's say there's a proposed change to federal policy that would impact the business.
Right, but Ms. Locklear was saying that this limits employees' right to hear information that they might find useful.
So I think what I was referencing is just the NLRA, protects the right of employees to support and join unions, but also the right to refrain from any such activities too. I don't know if that got.
Right, but you said something about them not being able to get the information that they might want to hear.
Right, and so Grayson gave a really good example earlier, and I really want to go back to this political matters section, which we've had a problem with for a while because of vagueness, but especially in the context of the conversations that we've been having around ICE and businesses. I just want to give you a really specific example here. So it says that political matters means matters relating to, and this is on page 2, starting on line 3, legislation, regulations, or public policy. And then as you go on here to what an employer may not do, you may not discharge, discipline, penalize an employer from attending communications around this. Well, I have to tell you right now, this is a huge contentious conversation that's going on across the country and potential liability for a business. So a business needs to mandatorily have a conversation with their employees about how we're going to handle a situation like that.
Okay, that's a different question than I was asking. I was asking how this prohibited employees from getting information. But it sounds like we just differ on the piece of what right the employer should have. But I was responding to your stated concern that the employees were somehow missing out on information. But I appreciate your answer. I think that's it. Thank you.
Thank you. Delegate Stewart.
Thank you, Madam Chair. Just following up a little bit on the Q&A from the parliamentarian. For Mr. is Miska?
Ms. Gamera.
Ms. Gamera. Okay, got it. I'll get that down. So just to be clear, as we sit here today, there is no final appellate decision holding a law like this unconstitutional, correct?
Not with respect to the California case or the Connecticut case. There are
none, right?
There's a half dozen Supreme Court cases that specifically deal with employer First Amendment rights.
But not this law.
They don't deal specifically with this law, but they apply, I believe, to this law.
Okay. And the California case was just one trial court ruling, right? And so it's still on appeal on the Ninth Circuit.
It's still on appeal.
Okay. And then the Connecticut opinion was procedural, as you covered with Delegate Wilson, right? So it was dismissed based on standing. They did not reach preemption. They did not reach constitutionality, correct?
That's incorrect in that the court specifically noted the First Amendment ruling by the California court in relation to the California law and expressed agreement that the court believed these types of laws violate the First Amendment.
But it was like dicta? Like they didn't reach it?
Yeah, that would be dicta, which I sometimes pronounce Ditka because I'm from Chicago, where Mike Ditka was
I appreciate
the
that. I'm not from Chicago, but
football
that's a
coach
very
for a
good,
long time.
That's a very good joke. I like that. Okay, so you're saying that, you covered the Constitution, you covered the First Amendment with Delegate Wilson, but you're saying the preemption issue. Where in the National Labor Relations Act does it say that an employer has the right to require employees to attend a union meeting?
Well, it specifically says in Section 8C that the expression of views, arguments, or opinions shall not constitute or be evidence of unlawful conduct. And I'm paraphrasing, unless the expression contains an unlawful threat or an improper promise. And, and that was added to the law based on employer rights that have been taken away previously. Congress actually amended the National Labor Relations Act to include that protection, and it was intended to be protection for employers.
Right, and I have Section 8C up here, but it doesn't say anything about forcing employees to listen to the views, correct?
Well, in fact, the prior NLRB case that was repudiated by the language in Section 8C specifically held that it was improper for employers to have mandatory captive audience meetings. That was a case that was decided in 1946, I believe, and that was called Clark Brothers. And then Congress, the very next year, amended the law to repudiate this finding that mandatory meetings were unlawful under the National Labor Relations Act. That was the reason that Section 8C was added to the National Labor Relations Act in the 1947 amendments. And as I indicated, at that time, freshman House member Kennedy, President, not yet president, but House member Kennedy at that time, he opposed other amendments that were being made in 1947, but he wrote his own report, his own personal report, to express agreement that employer First Amendment rights warranted protection. And that was his finding all the way through. As a senator in 1959, he made the other statement that I alluded to, that it was very important to have union election campaigns in which both sides present their viewpoints. And his point was, it's important for employees to understand how these issues work.
Yeah, I knew I always preferred his vice president. So if federal law protects what employers can say in 8C, but it doesn't say anything about federal rights to require attendance or any federal rights about retaliation for failure to attend, how can we stretch that out to say that Maryland legislators have no ability to regulate the area because we're preempted by the NLRA?
Well, the reason is that if you either rely on the NLRB's ruling in the Amazon case, which finds that these mandatory meetings, that was the specific rationale used by the board when they found that mandatory meetings in which employers address union issues violates the National Labor Relations Act. That's a basis for federal preemption of state action because the National Labor Relations Act, according to the board in that case, prohibits mandatory meetings like this. So that's directly on point. That deals directly with the same subject matter as HB 45, and that's one of the reasons why it's preempted. And of course, we also believe that it infringes on First Amendment rights.
Okay, appreciate you all.
Delegate Tomlinson.
Thank you, Madam Chair. Just anybody can answer this, but it's been touched on a couple times about political matters being banned. Can someone touch a little more on that, elaborate?
Sure. I mean, the example I gave was that, and I thought perhaps it was an unintended consequence of the bill, but based on the Senate hearing, it seems as though it is an intended consequence, is that there seems to be an underlying desire to prohibit a business from communicating or requiring employees to meet to talk about a potential change in public policy. And many of those public policies indicate or impact the business. And we don't understand the reasoning behind that, really, as to why we wouldn't want to allow businesses to do that. I understand that there's the D3 provision in there that says the communication line and language in it, but it's specific to job duties. And the example that I gave is changes in immigration enforcement, where you may want to bring your employees in to talk about changes, potential changes that are happening there, have been proposed there, and how that could impact the business and the employees that may not be exactly germane to their job duties. And that's something we've heard from both businesses and workers.
All right. Anybody else? Or good? All right. Thank you.
Delegate Ruth.
Thank you, Madam Chair. I'm not a lawyer, so I'm not going to delve into the litigation questions that have been discussed here, but I just was taking a quick look at last year's bill, and I wanted to follow up on the parliamentarians' questions about this number 3, where it says, this section does not prohibit an employer from communicating to its employees information that is necessary for its employees to perform their job duties. And I know, Mr. Wiggins, you had said, as a public policy person, that might cause problems. And you also said that there were concerns in the Senate about that last year. I just wanted to ask if you were aware, it doesn't look like that provision was in last year's bill, so it looks like it was added to address the concerns in the Senate?
I can't speak to why it was added. They didn't show us the bill before it was introduced. I would just note, it says from communicating. It doesn't say that they can require me to attend a meeting. And additionally, as I mentioned, the other example I gave, where you have a situation, a proposed public policy change that may not impact the specific job duties, but could impact the larger businesses.
Sure. And are you aware that also added this year that was not in last year's bill, it does not prohibit from
the law administered part, but that's after the fact.
Yeah, never mind. Never mind on that, but thank you.
Thank you. Delegate Fair.
Thank you. And just two quick questions. And Grace, apologies. I'm gonna try to really zero in on this because I'm really struggling here.
Okay.
I held staff meetings, every week for 20 years and worked with staff to make sure that and my company would fit squarely within these exemptions, as we would have mandatory staff meetings that had to do specifically with job duties. I'm trying to figure out an example, just one example, where a public policy issue that impacts the entirety of the company would have nothing to do with an employee's job duty, and so therefore the job duty language in the exemption would not be sufficient.
Immigration enforcement. I mean, you have a bill that's been introduced in this body right now, the MELT Act, which I believe holds a company liable if they allow an ICE agent on property without a judicial warrant. Okay. And so that's something that an employer may want to communicate to their employees that is not specific to their job duties. As in the language of the bill.
But you don't see that as being specific to their, I mean, literally, especially if they have
so the way we have it,
or undocumented immigrants working in their facility, I feel like that might have a little bit to do with their job duty at the end of the day. Who's facilitating?
Well, I don't think it would just be applicable to undocumented
business.
immigrants. I guess that's where we differ. I think somebody who's not an undocumented immigrant would also be, well informed to know about the potential public policy changes there. If you think it's only applied to undocumented immigrants, I
no,
differ.
I'm just saying. Like, I think that you're talking about ICE agents walking through businesses and concerns about that. I'm saying that does seem to be germane to somebody's job duty at the end of the day.
The way that we have it at my company is that we have a drafted job duty. So I have like a specific, very specific set of job duties.
Okay.
And so I would argue that the way the bill is drafted, that if something is outside of that very specific drafted statement, that I would not be able to communicate that information to them.
And to the gentleman, sorry, apologies. Your name again?
Oh, yeah, Mr. Miscamara.
Thank you very much. Sorry, apologies. And CBIA's challenge was just flat out dismissed on Friday. So can you help provide clarity? You said we're all coming together to talk about this issue, but the reading that I'm having, and again, I'm not a lawyer, but my husband likes to tell me that I argue like I think I am one. So
I understand.
Help me out here.
Yeah, the case was not dismissed. What the court found was that the Connecticut Business and Industry Association lacks standing to challenge the bill because the Department of Labor indicated that it would not enforce the bill against the Connecticut Business and Industry Association. The case remains intact, and the court scheduled a hearing for March 12th to discuss the path forward. That's the phrase that the court used. And the one very good point that you made earlier about mandatory meetings, it's true that the bill permits voluntary meetings, and as you know, and the bill also permits mandatory meetings in all kinds of other circumstances where the meeting is considered necessary to an employee's job duties. And what happens in many meetings, and there are meetings about safety issues, meetings about essential business issues, those occur all the time. But here's the thing, employees during a mandatory meeting might frequently raise questions about a union. And the bill says nothing. I mean, what the bill seems to contemplate at that point during a lawful mandatory meeting, if an employee asks a question, how do these issues work in terms of collective bargaining or a union? The bill appears to contemplate some mass exodus of employees from that meeting. It doesn't say where they go. It doesn't say how long they can be away. It doesn't say what happens if the employees don't come back for the rest of the day. It doesn't say anything about the practical implications. If an employee asks a question about a union during a mandatory meeting, what's the employer supposed to do?
All right, I would just, and I'm not asking a question here. I would just say that I think that you're mixing up employment terms of contracts, and like we have terms of contract. If you leave for the rest of the day and don't show up for your shift to do your job, then that's your right as an employee, and certainly our right as an employer to decide in an at-will state what we're going to do with that information. What we're talking about specifically is this specific meeting and whether or not we're having I would say appropriate conversations. So I'll just leave it there on that note, and thank you, Madam Chair.
Thank you. Delegate Solomon.
Thank you, Madam Chair. Appreciate this conversation, and I'm not a lawyer either, although similarly my wife likes to say that I pretend to be one. I guess I'm having trouble with the response on the political matters, and Grayson, to sort of go to your comment about the proposals to change, I feel like we're conflating two issues here, right? If a law passes, right, if the General Assembly and the governor sign a law to change the way in which the state conducts immigration policy, using that as an example, it is not, in my view, reading this bill, inappropriate for me as an employer to bring my employees together and say, this is the new law of the state of Maryland. I need to have a conversation with you about how we manage enforcement and how we handle our businesses' engagement with now settled law. Just like if we were talking about tax law, right? If I'm an accountant and suddenly the state has changed its tax law and our supervisor brings us together and says, by the way, we now have a new tax exemption in the state. You're about to start filing taxes for residents, you need to know how to do it. There's that. it is very different to me if an employer says there is a bill under consideration in the General Assembly, which was the example that you gave, and I do not like it, and it is bad for my business, and I want you to lobby against it, right? I think our colleagues on both sides of the aisle here, I wouldn't want, as somebody on one side of the political aisle, to put my views in front of an employee if they don't disagree with me, just like if I were working in a business that were run by people who I didn't agree with, who were conservative, that they were preaching to me. I think vice versa. So I think there's a conflation here of established law and how that interacts with the business. I don't read proposals to change anything around existing law or settled law. The examples you keep sharing seem to be about lobbying on proposals before the General Assembly or before a legislative body. Am I misinterpreting that? I think we just need to clear up this misconception about the bill.
I don't think I was specific to lobbying. I think it was more about relaying the information. I mean, I've been asked by members of this body and the Senate to ask a company to say, what would the impact of a bill, can you analyze the impact of a bill on your company? And then they go back and they have a meeting with their employees and they ask them to run the numbers. That would be prohibited under this.
No, you don't need, I don't think there's a difference between compelling your employees to all come together and grabbing a supervisor and saying, hey, just out of curiosity, what would, or you're also not saying to the supervisor, like, you then have to go do something around it. It's just asking, like, as part of your job duty, I need you to crunch numbers. So again, the other thing I will say, and you all have heard me say this before in legislation that we've worked on collectively, there's a difference between coming in completely opposed and saying, we understand, maybe we have a disagreement of opinion, like, do you have a set of amendments to tweak this, to make that language, to clarify that we're not preventing what you're talking about? Because again, if we're all operating in good faith here, we're not trying to prevent somebody from crunching numbers. I think what we're trying to prevent is an employer bringing all their employees together saying, I do not like this immigration bill that is in the General Assembly, and I'm going to preach to you about why I don't like it. So where's the middle ground there, I guess?
I guess what my position would be, and I apologize for interrupting you earlier, that was my intention.
No, it's fine.
But I think my client's position is that the bill is written so broadly. I hear what you're saying, I do, but it's going to have unintended negative consequences as well. And I think that's a reality that I'm hoping we can come to some understanding on too, is that the scope of this, it could create situations where businesses can't, alert their employees about a potential change, whether it's this body or the federal body when the president tweets something out, right? I mean, that's a proposed public policy change. That's the reality of the world we live in now. And so I hear what you're saying. I don't want people up there preaching to their employees about stuff that is, just way outside the scope. I get it, right? I get that. But I think what we also don't want to do is prohibit businesses from being able to react to things and to inform people, even if it's not specific to a job duty that maybe just be germane to their general day-to-day work. So, yeah.
I guess my last request would be if your lawyers and some folks smarter than us could propose language that bridges that gap, that would be really helpful, I think, for our committee. Thank you, Madam Chair.
Thank you. Delegate Wilson.
And only because, so again, when I read the Connecticut holding, it says that basically that it was, summary judgment was granted because the First Amendment right to speak to its employees was not impacted by the law. That's what I've read in everything that I pulled up. Meaning the way the current law is, the Connecticut law did not affect the employer's First Amendment rights. Now, I've read that in like 8 different things, and granted, I've got to find it, but it literally says, law did not impact their First Amendment rights. That's why they brought it up. It was sent back basically on summary judgment because it did not affect the First Amendment rights of the employer. Secondly, we can all agree, I'm hoping at this table, that if I become a budding and can afford to become a budding Scientologist, I don't have a right to take my employees back twice a week for an hour and preach to them about the magnificence of Scientology. We can all agree on that, right? I'm asking, because maybe that's our big disagreement, because if I start the Green Party Wilson and I start talking every month about and making everybody come and to hear about my Green Party and how important it is and I mandate that they stay, I would assume we can all agree that as an employer, I shouldn't force my employees to listen. And if we don't, I'll hit this button, we can be done because we just have a difference of opinion. If we do what the good delegate said, then help us out here. Because what I can't wrap my mind about what you're saying. It sounds like you're saying employers should be able to say whenever, whatever, do whatever.
No, and Delegate, I appreciate the question. I don't have an opinion about Scientology or what an employer might say about Scientology. And well, I don't disagree with your opinion with respect to Scientology. However, with respect to an employer who is prohibited from having meetings, mandatory meetings, voluntary meetings, to the extent that the law discriminates on the basis of content, specifically content concerning an opinion about unions, then I believe that's what infringes on First Amendment rights.
And you agree that this bill doesn't do that, right?
No, I believe that it does do that.
Because it does allow them to speak. It just doesn't mandate people to show up.
I believe, consistent with the First Amendment cases that deal with these issues, the fact that the bill discriminates on the basis of content, it singles out a particular type of speech, which is speech about unions. That's what renders it a violation of the First Amendment. And I understand that you view this differently and respectfully disagree.
Worries, I'm done. Thank you.
Okay, so I don't see any more questions, but you just made a comment, Ms. Gamera, though. Doesn't this bill, you said it singles out specific conversation, you talked about unions, but I thought this bill is providing protections for additional topics like political, not policy, political as well as religious. So I'm confused on how it singles out the unions only.
Well, there's an array of subjects that can be discussed and are discussed in workplace meetings. And the fact that the bill, among what the bill prohibits are opinions about unions, it discriminates between union-related speech and many other kinds of speech that do not involve opinions about unions. And that's what I meant. It certainly does have other exceptions, but the fact that among the things that it prohibits are opinions about unions, that's one of the reasons why I believe it infringes on First Amendment rights.
Okay, and I'm not a lawyer, and I've been trying to follow the conversation, and I've been talking to our counsel. But so is your issue the fact that, and I'm going to try to follow all the conversation we've had on this bill, at least from your panel. So is your issue, because you referred back to the preemption of the NLRA, so is your issue that because it specifically talks about unions amongst the other ones, that the union being included in this exclusion or what have you is the primary problem that you all have with the bill? Like if it didn't include unions, it just include political or religious, you have no problem with it?
I only am expressing an opinion with respect to the limitation pertaining to unions because my background happens to deal specifically with that. I believe that the First Amendment issues raised in the bill are more expansive than the bill's prohibition that relates to unions, but I don't have a particular opinion.
Got it, you're just here to speak only really to the union aspect, more or less.
And that's the issue as to which I have a background that I think permits me to have an opinion about that.
Got it, okay, thank you. Seeing no more questions from the committee, thank you to the panel. This concludes our bill hearing on HB 45. Thank you, everyone. We will move on to Delegate Lopez presenting HB 724. And we bid you adieu, Delegate Vogel. Vogel. Yeah. Good afternoon, Delegate Lopez.
Good afternoon. The seat is very warm.
It definitely has gotten hot in here.
Yes,
for sure.
hopefully I can.
All right, you may begin.
The temperature down. Good afternoon, everyone. Good afternoon, Chair, Vice Chair, members of the committee. For the record, I'm Delegate Leslie Lopez, representing District 39, here to present HB 724, Employment Discrimination. caregiver status. Maryland has long been a leader in advancing fairness and opportunity in our workplace. Our laws already protect discrimination based on race, gender, age, disability, sexual orientation, military service, and other distinctions. But today, a major gap remains, one that affects millions of Marylanders every day. Under current law, there is no protection for workers facing discrimination because they care for a child, an aging parent, a spouse with a disability, or another loved one in need. This bill closes that gap by adding caregiver status as a protected class under Maryland's employment anti-discrimination statute, ensuring that no one is penalized at work simply for fulfilling family responsibilities. The problem is clear and well documented. Employers too often assume that caregivers, especially women, are less dedicated, less flexible, or less deserving of advancement. As a result, caregivers are passed over for promotions, denied hiring opportunities, or even forced out of their jobs. National studies show that family responsibilities discrimination disproportionately affects women, single parents, workers of color, and the very people who hold communities together through unpaid care work. This bill is not a new idea. In fact, in 250 states, counties, and municipalities, this is already law, caregiver protections. In 9 counties and municipalities in Maryland, this is already law for family protected status. But what we need now is a statewide commitment. Maryland should not lag behind our neighbors, affirming that caregiving is not a liability. It is a vital contribution to our families, our economy, and our shared humanity. Together, we can ensure Maryland stands with its caregivers because protecting caregivers means protecting families, communities, and our state's future. By passing HB 724, Maryland would take a step forward toward family stability, economic security for all Marylanders. We affirm that no one should have to choose between the job they need and the loved one who needs them. Thank you, and I urge a favorable report in my most calm voice.
Good afternoon, Chair Wells, Vice Chair Kerr, and members of the committee. My name is Sarah Westrick. I am the Advocacy Director for AARP Maryland. On behalf of our 850,000 members across the state, I am supporting HB 724, the Caregiver Employment Discrimination Bill, and thank Delegate Lopez for introducing this important legislation. AARP is the largest nonprofit, nonpartisan organization representing the interests of Americans aged 50 and older and their families. We urge the committee to support this critical legislation that recognizes the invaluable contributions of family caregivers and offers them much-needed employment protection. Caregiving is a major economic issue. Maryland has 1.16 million family caregivers. That's 1 in 4 adults, and most of them are working age and employed. You will hear from a member of our advocacy team in a few moments about her personal journey. For full data and analysis, please refer to my written testimony and the attached AARP research. I will note today that 64% of family caregivers work while caregiving, and many of them provide more than 40 hours a week of unpaid care, essentially adding a second full-time job. And 38% of caregivers report major financial hardship, including depleting savings, unpaid bills, and increased debt. When caregivers are pushed out of the workforce, the financial fallout is long-term. They lose wages, health insurance, Social Security credits, and retirement contributions. These losses often hit sandwich generation workers at the very moment they need to build retirement security, yet discrimination forces them into an irreversible financial decline. HB 724 is a simple, practical measure. Adding caregiver status as a protected class ensures workers aren't fired, demoted, or penalized simply for caring for their loved ones. We urge a favorable report. Thank you.
Hi, I'm Nicole Tortorello. I am not from the advocate community. I'm the managing attorney for the Workplace Justice Project at the Public Justice Center, and we also urge a favorable report. As was already said, the need for this is apparent in Maryland with 1 in 4 adults in the state having caregiver responsibilities and 2/3 of caregivers holding other jobs while also providing care. Additionally, 30% of family caregivers have a household income of under $50,000 a year, meaning that this is also hitting low-wage workers in Maryland particularly hard. As Delegate Lopez mentioned, this bill would bring Maryland in line with 250 other states and localities that already ban discrimination based on an individual status as a caregiver, including 9 counties and municipalities in Maryland that already protect workers from discrimination based on their family status, which may include caregiving responsibilities. But workers outside those counties and cities in Maryland currently have to rely on a hodgepodge of federal laws that may not adequately protect them from common acts of workplace discrimination, like refusing to promote someone who has children or opting not to hire someone because they mention that they care for elderly parents during their job interview. All workers deserve dignity and respect, including workplaces free from all forms of discrimination and harassment, and this bill would further this goal for working caregivers. So the PJC supports a favorable report, and I'm happy to answer any questions. Thank you.
Thank you very much. We do have a question from Delegate Wilson for the sponsor and the sponsor panel.
Thank you. I know we've had bills in the past. I think one was they wanted veterans and their spouses to be a protected class. For me, my concern then is the dilution of what that word means. And by the way I'm looking at the definition, every single person in this room most likely would now be a protected class. If you care for a mother, a father, I have 3 children, and I'll say this because when the EEOC first started it was really to deal with the ramifications of not just slavery, but Jim Crow, and creating these protected classes to make sure these individuals didn't suffer further harm as a community. And we have expanded the protected class to include gender, a multitude of things that, even sexual orientation, that by choice you're just put into. Though when I look at this bill, it now puts almost every single person in this room as a protected class. Everybody. So the word protected class actually is meaningless. So being an African American now becomes somewhat meaningless because we're all protected class. Being gay becomes meaningless because now we're all protected class. And I think coming up the way I did, and I'm also old, so maybe I'm just not getting it, at some point, and I believe this may be that point, and I really appreciate what you're going through, but this will almost make the word protected class meaningless because everybody's in it now. And I don't know how else to express myself on this, but by doing it as such, and basically everybody will have the same status as an African American, as an American Indian, as somebody who's homosexual. It's like every single person, by the way the bill is drafted, will have this status. And at that point, there's no use in having the word protected class. I mean, and just help me out here, because I know your intent, but you understand what I'm saying?
Sure, no, absolutely. And I know this is an issue that you've been very passionate about for a long time. And so I fully respect that. And if there is a way forward that you're willing to work with me on, like 100%, I am there, and we will figure out how to get this language to a place that encapsulates the concerns that you have.
Because of course you want to provide protections for the people, and I agree. But at some point, if this bill goes by, I don't believe anybody in this room would not consider themselves a protected class. And it really, it's diminution of being an African American and the life that I've come through and the struggles that I've gone through, which is why we have protected classes of people. And I just wanted to express my opinion. And I apologize if it was offensive, because I understand the point. I will hope you understand my point.
Sure, no, absolutely. It's a point well taken. And again, we can continue to talk offline if you're open to that, to get this to a place that you feel is respectful of everyone's lived experiences and also is respectful of the concerns that we're seeing within the caregiving community. I would offer this, if it provides you any comfort, the definition of caregiver status, the language that we use in this bill is directly taken from New York State's, I think the acronym is like HCCR. It's basically the equivalent in New York State to what we have as the MCCR. So this is not language that we invented or that we're recreating the will. It's already statute in New York. So, but I understand broader than the technicality of the words, the impact of a more broader inclusion. And so again, happy to work with you online to figure out how to finesse things that fit the letter of the law and also the spirit of the law that you're trying to reflect.
And again, because the way I read it, just if you care for a minor child, an individual with disabilities, or you rely on a caregiver for medical assistance, and the familial relationship has to be caregiver's child, caregiver's spouse, domestic partner, caregiver's parent, caregiver's sibling, caregiver's grandchild, caregiver's grandparent. That encapsulates every single person in this room, and therefore African American, female struggling in the workplace, all that, it puts it all on that same level. But I appreciate the work. Thank you. Sure.
Thank you very much, Delegate. Okay, seeing no more questions for the sponsor panel, or at least we do have one virtual witness, Ms. Teresa Robertson, who has joined us. We can see you. Good afternoon, Ms. Robertson. You have 2 minutes to present.
Good afternoon, Chair Wells, Vice Chair Kerr, and members of the committee. My name is Teresa Robertson, and I'm a resident of Howard County and a volunteer with AARP Maryland's advocacy team. I'm here today to voice out strong support for HB 724, the Caregiver Employment Discrimination Bill. I want to begin with something simple but important. Caregiving is leadership. Caregivers coordinate medical appointments, make quick decisions, and still show up at work ready to do their jobs every day. These are exactly the skills most employers should value, like time management, prioritization, problem solving, and the ability to work under pressure. But too many caregivers don't feel safe telling their employer what they're really dealing with. They worry that they'll be viewed as unreliable. And I personally remember taking calls from my husband's doctor in my car, hoping nobody noticed because I was afraid of losing opportunities. Now, discrimination isn't always dramatic. It can sometimes be subtle, like being reassigned or passed over for projects or slowly pushed out. That's caregiver discrimination, and it shouldn't be happening. The truth is, employers should want caregivers because they're capable, resourceful workers who deeply understand the value of a stable work environment. And yes, every one of us at some point may be touched with caregiving. The workplace is already filled with caregivers, but we don't see them because many of them feel the need to hide. HB 724 is about fairness. It ensures caregivers aren't punished for doing something nearly all of us will have to do someday, and that's taking care of the people we love. Thank you for your consideration, and I respectfully urge a favorable report on HB 724.
Thank you very much, Ms. Robertson. We have a question from Delegate Schindler.
Thank you very much, Madam Chair. A quick question, anybody could really answer this, but is there a way that we could, respect my colleagues' concerns with this, but also be mindful of the fact that I think you've hit on something that I was very shocked to find that was not against the law, in that at one point in time, my son's mother applied for a job and inquired about the maternity leave benefits. We later found out through a friend that worked at that company, that's why she didn't get the job, is because she had inquired and they were like, oh, well, she's going to be out on maternity leave, so we're not going to hire her. So I think you've hit on something here, but I didn't know if maybe there was a way we could narrow this to some way that would respect that, but also handle a very important issue that you've hit on.
Sure, I think that's the art and craft of lawmaking, is coming up with something that addresses the true impact that we're trying to achieve, but is reflective of and respectful of everyone's lived experiences. To say the thing out loud, I noticed on the fiscal note, or I should say, there's no opposition outside the Chamber of Commerce, and I think I've addressed their concerns with my previous answer. But we had an informational submission from MCCR, which is the body that's a state agency that receives complaints about discrimination and harassment first, and that's the first layer of things. And they said that in order to keep up with what they would consider the new complaints they would receive, they would have to hire 2 staffers. And so these are the people who are the experts on employment discrimination. And from their perspective, in order to keep up with how many, prospective complaints there would be, it would take 2 additional staffers. So I think that underscores how frequent this is as an issue. And we do have protections already around gender. And many times what's seen as caregiving work is seen through a lens of gender, right? Because it's women who are mostly doing this type of thing. And of course, women who would be pregnant. So there's that. But this is already in law in 9 counties and all the major counties and municipalities. So there's a way that it's working.
Thank you very much. Seeing no more questions from the committee, thank you for the bill, Delegate. Thank you to your witnesses as well. We will now move on to HB 864, which I will cede to my Vice Chair, and he will proceed.
Good afternoon, Madam Chairman.
Good afternoon, Mr. Chair and colleagues. For the record, I'm Delegate Melissa Wells, and I'm here to testify in support of House Bill 864, the Maryland Workforce Apprenticeship Utilization Act. HB 864 requires that contractors and subcontractors employing 4 or more individuals on covered prevailing wage public work projects utilize registered apprentices for at least 20% of total work hours. The bill uses a percentage of work hours to reflect the variation of labor needs across the covered crafts and to provide flexibility while still establishing a meaningful participation standard. I do want to just flag that there are some amendments. After introduction, I realized that we had left off some amendments that were added in previously. And so we'll make sure that we get those addressed, specifically with regard to getting rid of a really vital training fund and cents per hour that's contributed to that training fund. So you'll probably see that listed in some of the unfavorable or favorable with amendments testimony. So we will be adding that back in. So I just want to make sure that folks are made aware of that. And that's something that we've done previously. It was a complete oversight on my part. I do want to and I want to also clarify that we have additional amendments just to making it clear that we will not be altering the definition of a covered project. So while prevailing wage applies to contracts valued at $500,000 or more, this legislation will apply to the utilization requirement to prevailing wage contracts that currently exist of $250,000 or more. So it does not change our prevailing wage threshold. Third, the bill applies only to projects that are subject to the prevailing wage law. It does not extend to projects that are exempt from prevailing wage requirements. And I think more importantly, this is our 3rd time or 4th time, I have my numbers a little turned around, but presenting this bill. And I think ultimately the intent of this bill is that the state invests nearly $600 million in workforce development initiatives. This includes apprenticeship expansion, supporting both employers and workers. I think for us to fully really maximize those investments, I think, and also to, I think, address some of the broader conversations that we have had previous years, and maybe we'll hear more in this committee either this year or in years to come, is that we do have a shortage of skilled tradespeople. I think there's oftentimes conversation when locales would like to think about exploring geographical or the idea of are we employing more Marylanders to do a lot of the construction work here for the state and in communities. Oftentimes it's said we want to do that, but then the response will be, well, we don't have enough skilled folks that are Maryland residents to do that work. And so this is really seeking to help us establish a pipeline and a pathway for us to be able to do that. And just for the record, just so folks know, nearly $10 million annually is invested by way of registered apprenticeship programs into workforce development dollars. And these programs also serve as economic engines that build critical training infrastructure and provide pathways to high-paying careers. I will also add that we have had conversations with the Associated Builders and Contractors, or also known as the ABC, and there's a slew of amendments that we're in conversation with them about that I think, for the most part, I think we're almost all the way there in terms of accepting them. But we had a really, really earnest conversation, and I think we're pretty much in the same place when it comes to, I think, where we want to go. This is a starting conversation, so I think, you know, I think if you think about the long-term goal, because every bill gets introduced, and the opportunity, once it's introduced, is for us to add amendments and have conversations. So I'm asking that the committee, the body, and all those who are interested in the outcome of this bill really use that lens of exploring how we can share, or how we can find a resolution that values, I think, our overall commitment to getting more people into the skilled trades. I wanted just to mention in some of the unfavorable testimony, rigid mandates that risk shrinking bidder pools, raising costs, and sidelining qualified contractors. I think the conversation that we are already engaging with the ABC that represents a large number of contractors, I think that there seems to be some kind of pathway that they see forward with this bill. So I want to just kind of, you know, I think that's a good way for me to speak to anyone that might have questions with regard to some of those commentaries. It says, you know, largely union-sponsored programs. Overall, there are a lot of union apprenticeship programs. I'm not going to sit here and tell you that they don't exist, but there are programs that are not union associated with, right? This bill is not about pushing a union process. This bill's going to push everyone, I think, to think about how they can help intentionally be a part of building our skilled trades professionals here in the state of Maryland, in the region. And so I just I wanted to kind of speak to that, because I think sometimes it's assumed, but it also doesn't acknowledge that there are non-union or non-multi-employer programs that are thriving in places like in Baltimore, where I reside. So I just wanted to speak to that a little bit. And with that, colleagues, I ask for a favorable report. Thank you.
Thank you. We have a question from Delegate Wilson.
Deja vu.
My, how the tables have turned.
I know.
Well, and Madam Chair, I don't know in the past what happened. I don't know what villain was messing with your bill, but I'll say that you know, I think that my only concern has been making sure that the money that we spend stays for Maryland training facilities. It really is. That's just my biggest issue, is making sure the monies we invest, because there are a lot of places, you know, a lot of where we're short at. I just, you know, that was always been my biggest concern. Again, I think you're in the right committee for this bill this year. I think, you know, the chair seems open-minded to your bill, so I'm sure it'll do well. But I do hope that, you know, that's always just been my concern, to make sure that we're just benefiting Marylanders. I don't want to send money to Pennsylvania and Delaware in their training programs, because Maryland deserves that money, so we don't have to keep bringing people from out of state.
Absolutely.
And whatever happened in the past, I hope, you know, hey, look, it was the past, right?
You know, in previous years, there was a chair that expressed a very similar sentiment as you have. And I was extremely agreeable to finding ways to make sure that we ensure it. Ultimately, the goal is to really invest and build up our Maryland workforce. And that is the goal of this bill. And albeit there's other programs in other places, I would like for us to rival those programs, and I think to really stand toe-to-toe with them. And that way, as we move forward, hopefully with the rebuild of the Key Bridge and things like that, that we have residents from Maryland, from the various regions that are adjoining it, that are part of rebuilding the bridge.
Well, I think I support my chair.
Okay.
I've always supported you.
That's great to
I don't know who
hear.
else these other bad people are, but I think it's a great idea, so thank you very much.
Thank you very much.
I see a question from Delegate Schmidt.
Thank you, Mr. Chair, and thank you, Madam Chair, for bringing the bill. And I know you mentioned some amendments regarding the bill. Would those amendments maybe address where applicable, right? If we don't have enough people participating in the apprenticeship program, is there a way to grow? Because we got to start at the bottom, and we probably need to start in high school, getting into trade school, build that program so that we have a pool of potential labor. I just wanted to know, I understand the goal of the bill. I think it makes total sense. I agree with the premise of the bill. Just don't want to get to a situation where it's we don't have
Correct.
the people.
Yep.
I think we all would agree with that.
100%. I think everyone who has support for this bill would agree with you. We don't want to bite off more than we can chew. And so I believe that there, within the amendments that, and I don't know if the committee has them or not, and I'm sure we'll hear from some of the favorable with amendment testimony. But overall, our goal is to create, repeat a goal. Our intent is to create a goal that is achievable and to also look at how we build the options within this legislation that helps us move towards accomplishing it, and not setting a goal that is overly ambitious, that also, and I think within the language, there's different ways in which we can move towards accomplishing the goal. There was some suggestion of perhaps counting in some way folks that were, as a part of this goal, that had finished an apprenticeship in the last 3 years. So this is something that we have to start somewhere. We have to work with the Department of Labor in terms of evaluation, and then thinking about where are we in terms of meeting a goal, where do we have more room for opportunity. I believe that you have a chair who's really enthusiastic about working with the industry more broadly to think about like what is our 5, 10, 15, 20-year goal for helping Maryland create a thriving workforce that is Maryland-based. So thank you for the question.
I agree. Thank you. And I like the fiscal note.
Yes.
Thank you.
Good. Thank you.
There are no more questions.
All right.
Thank you for your testimony, Madam Chair. We do have a favorable panel. We have one in-person witness and one virtual witness. I'll call Ray Baker and Rochelle Ramsey Walker. Go ahead, Mr. Baker.
Thank you kindly, Chair. Good afternoon, Chair, Committee. My name is Ray Baker. I'm the Maryland Director of the Baltimore, D.C. Building Trades Council. You all have my written testimony, so I will not be before us too long. I echo the sentiment that Delegate Wilson, who some of you on the committee identified as the parliamentarian, so we'll start using that language as well. I echo the sentiment and concern of the delegate, quite honestly, about the want for Marylanders to be on these projects. Our affiliate, 28 different affiliates across the Baltimore, D.C., and Northern Virginia region, particularly here in the Baltimore area where I do a lot of my work out of, and throughout the Southern Maryland area and Anne Arundel County as well, we have a number of workers who are ready to go to work. Our unions are ready to bring folks in and put them onto jobs as apprentices, and quite honestly, though, we need the work. This type of legislation will empower us with the kind of work to be able to ensure that the concerns of this committee, that Marylanders are building are the ones who will join our apprenticeship programs. Our apprenticeship programs are amazing, and while we respect Madam Chair who says there are more than union apprenticeships, we're with the union, so we're going to talk about the union ones for right now. And so we would love to have union apprentices doing the kind of vital construction that the state sorely and desperately needs. And lastly, I would mention that if you all are diligent in passing this bill, that particularly if there's prevailing wage, that there's the necessary oversight from this committee and this body to ensure that we do not have wage theft on state projects. We do not want our state dollars going outside of our state, and we do not want to have that state dollars being allocated and workers are not getting paid what they deserve. We believe that registered apprenticeships and the utilization of those registered apprenticeships are a key pathway to doing that. So we support this committee and we urge a favorable report, and I look forward to answering any questions that anyone may have.
Thank you, Mr. Baker. Ms. Ramsey Walker, go ahead. You have 2 minutes for your testimony.
Good afternoon, everyone. Thank you all for allowing me the opportunity to testify in support of HB 0864, the Apprenticeship Utilization Act. My name is Rochelle Ramsey Walker, and as an apprentice enrolled in the commercial painting program at the International Union of Painters and Allied Trades District Council 51, I believe that the legislation key to shaping for apprentices and the entire construction workforce in Maryland. This legislation emphasizes diversity and inclusion within the construction industry, and it also provides the opportunities for individuals like myself who may have faced barriers in the past. It creates a more accessible pathway, not just for women, but for minorities and individuals from different backgrounds to enter and thrive in the construction trades. Job security is of the utmost importance, especially now. And this act focuses on apprenticeship utilization, not only securing our present opportunities, but also ensuring a thriving workforce for years to come. By investing in apprenticeships, we contribute to the long-term success and sustainability of the construction industry in Maryland. My experience as an apprentice has been marked not only by skill development, but also personal growth. This act reinforces the importance of our roles, encouraging a sense of commitment and professionalism that extends beyond our apprenticeship journey. It sets the stage for a fulfilling and promising career in the construction trades. As a college graduate, it was very difficult to find employment to financially support my growing family. But through apprenticeship pathways, I'm able to sufficiently support my family in ways that at one point I could only dream of. I want to thank Chairwoman Wells for sponsoring this Apprenticeship Utilization Act bill. As an apprentice and as a constituent of Maryland, I support this legislation, believing that it will not only positively impact my journey, but also contribute to overall success and vitality of the construction industry for women and all workers from all walks of life in our great state. Thank you.
Thank you for your testimony and for being with us today. Do we have questions for this favorable panel? Seeing none, thank you again for joining us today. We do have a panel of favorable with amendments. I will call up Carrington Anderson, Michael Adams, Sean Malone, welcome. Go ahead whenever you're ready.
All right. Good afternoon. On behalf of MMCA, my name is Sean Malone. I want to thank the chair for the introduction of this bill, but really for including the Associated Builders and Contractors and the Maryland Minority Contractors Association in a conversation about the contents of this bill prior to today's hearing. And I will tell you that over the past 3 years in the state, we have not been included in many rooms and discussions. So this is a great conversation. 12 years ago, ABC, MMCA came together with the AFL-CIO and created the Apprentice Training Fund. We sponsored the bill, we helped draft it, and we passed it because at that time we weren't able to bring apprentices necessary in the numbers we wanted on the job sites because we just didn't have the programs. That program, by taking 25 cents an hour of worked on public works projects, has enabled us to build programs. And in Prince George's County, in Western Maryland, in Baltimore City, we've built multi-craft training centers, and we are developing apprentices, and we have pre-apprentice programs. So we are in support of the bill. We have offered amendments. But to the question that was asked earlier, Delegate, it's important that we do this in a thoughtful way and that we're not punishing contractors because we're not able to supply the apprentices. So we have proposed amendments that would enable an individual or a company that if they bring an apprentice on the job, but they can't meet the threshold, then they will pay the 25 cents an hour to continue to build the Apprentice Training Fund. That's a fund that we need to continue to build in the state. I think the chair sees eye to eye. We spent a lot of time and thoughtful time, and in fact, some of the I think the chair is surprised at we don't want any exceptions. You're either on the job with apprentices or you're paying into the Apprentice Training Fund. Because this is what's good for the industry, it's what's good for Maryland, and as the delegate said, we want this money to remain in Maryland and develop our workforce. So we would testify in support with amendments.
Good afternoon, Madam Chair, members of the committee. Michael Adams on behalf of Associated Builders and Contractors. I want to echo what Mr. Malone said. We were very excited to meet with Madam Chair to go through this bill. This is a bill that we have opposed in the past, but we are here favorable with amendments because we support what this bill is trying to do, and we think with some tweaks we can make it really great for Maryland industry, really great for Maryland workers. I wanted to talk about some of the specific language that we are looking for in an amended bill, and I think Madam Chair is on board with many of these items. First and foremost, I think unintentionally the bill stripped away funding for the Apprenticeship Training Fund. We are restoring that vehicle, so the 25 cent per labor hour charge if an apprentice is not brought onto the job site. That fund goes and funds. ABC has apprenticeship training programs in East Baltimore, in Beltsville, that turn out many well-qualified tradesmen and women every year. We do want to remove the waiver program for instances when apprentices are not available. Under the currently constructed bill, an entity could go to the geographic area, including outside the state, to see if there are apprentices available, and if there are not, they would be able to waive out of the program. We want to strip that waiver program away, essentially say you're either bringing apprentices to the job site or you're not. If you're not, you should be paying into the fund and supporting the apprentices that are being trained in Maryland. We also want to allow a hybrid approach. There are instances where a contractor or subcontractor can't bring the required 20% of labor hours in terms of apprentices. We don't want to discourage them from bringing any apprentices, however. So we want to have a balance where if you are able to meet part of that goal, the rest of the goal can be supplemented with that 25-cent per hour charge that's in existing legislation. So, with that, we would urge a favorable with amendment report, and thank you.
Thank you, Madam Chair, Mr. Vice Chair, members of the committee. My name is Carrington Anderson here on behalf of the Maryland Association of Counties in support of the bill with an amendment. Our members really do support the efforts to encourage the use of apprenticeships. Our membership has no issue with the 20% standard in the bill. The one thing that counties did have a little bit of concern was with the authority given to the Department of Labor to increase or to set that applicable percentage annually. I think one thing we would ask the committee and the sponsor to consider is keeping that 20% standard, and then if the General Assembly determines that that standard needs to change, then bring that back for public debate instead of setting that annually. So again, really do appreciate the bill and the encouraged use of apprenticeships, but for those reasons, we would respectfully ask for a favorable with amendment report. Thank you.
Thank you. Do we have questions for the favorable with amendment panel? Mr. Adams, were you able to get through all of your amendment suggestions?
I was not. There were a few more. I hit the highlights. But
okay, why don't you take a minute and go ahead and give us those.
Thank you very much, Mr. Vice Chair. Actually, piggybacking on what Mako was saying, one of the ideas that ABC had regarding the secretary was to delay implementation slightly and then have a staggered review every other year, still within the purview of the secretary. However, listing the data points that they would have to go through in order to raise the percentage rate. 20% is a relatively lofty goal. It would be the highest in the country. There are a number that are at 5 or 10. So having that staggered approach, we would encourage, and then also having that data of how much is the program being utilized, how much are apprentices being utilized year by year, I think will solve those problems.
You can ignore that.
The other was we wanted to expand the definition of apprentice, which is in the original law. It says a qualified apprentice or journey worker. But then when you look at how that term is defined, it talks about someone currently in an apprenticeship program. We think there is a desire and a need for young tradespeople on a job, those who are within the first 3 years of graduating an apprenticeship program. We would encourage the committee to look at an approach that allows for those young journey workers to be counted against the 20% cap. Finally, a violation under the current bill talks about Maryland False Claims Act jurisdiction. We would encourage the committee to remove that jurisdiction, however, to impose a fine for the failure to comply at the discretion of the secretary. The False Claims Act seems sort of overly punitive when we're trying to encourage what is ultimately a good thing for the state and not completely easy to comply with all the time. So those would be our substantive amendments, and certainly happy to meet with any member of the committee to go through them in more detail.
Okay, thank you. Seeing no more questions, thank you. And we do have an informational witness, Kevin O'Keefe.
Thank you. Good afternoon, Chair Wells, Vice Chair Kerr, and members of the committee. My name is Kevin O'Keefe on behalf of the Independent Electrical Contractors Chesapeake. We're located in Laurel. We have about 1,300 apprentices currently, so we support apprenticeship very much, and I thank you for this bill, Madam Chair. I just have a couple points that some had been alluded to by the ABC panel, but I just, on page 8, lines 8 to 10, the 20% threshold may be unrealistic, but if there's ways to make that work by counting young journey workers or having a hybrid where you would pay into a fund, that would be good. And then the question about the what criteria would the labor secretary use in order to create a percentage for the following years? I think that would be good to try to flesh out some criteria. And then the one on page 10, lines 24, 27, about 90 calendar days before a contractor signs a participation agreement with an apprenticeship program, there may be more time needed than 90 days to do that. And then just on the one other thing is, I think it was eliminated about putting money into an apprenticeship program fund that currently exists. I mean, we would, I think, like to have the option to put money from contractors into one of our funds that we use for our apprenticeship program. And then just monthly reporting, sometimes it's hard to have a lot of paperwork, and it creates challenges for these businesses. But these are just minor suggestions, and thank you.
Questions for Mr. O'Keefe? I don't see any. Thank you for your testimony
Thank
today.
you.
That ends the testimony for House Bill 864 and ends the hearing for House Bill 864, and I will turn the chair back over to the chair.
Thank you, Mr. Vice Chair. We will move on to Delegate Solomon, HB 532. Delegate Solomon, you have a sponsor panel. Yep. Katie Nash and Josh Fannin.
Good afternoon, colleagues. This is officially my first bill hearing in front of our wonderful new committee. It's nice to be here. Hey, on this side of the table. For the record, Delegate Jared Solomon presenting on House Bill 532. This is a bill that we've heard twice already before in the Appropriations Committee, but obviously is new to this committee. And I just want to kind of lay out at its core what it's about. So, you know, we heard, as we were sitting here debating the earlier bill, I think we heard the fire engine going past. We don't know where they were going, right? They could have been running to a 5-alarm fire where the folks on that rig were risking their lives. Some of them might not come home tonight. But more than likely, the folks who were on that rig would get overtime if they worked 42 hours or more a week. Unfortunately, for a number of jurisdictions in our state, that is not the case, because you probably didn't know that firefighters as a whole are subject to Fair Labor Standards Act at the federal level, which actually sets the overtime threshold for firefighters where you have to begin, the employer has to begin paying them overtime at 56 hours, right? Most of us would say that's crazy, right? In almost every other profession, you work more than 40 hours a week, you're paid overtime. In Maryland, by collective bargaining, the majority of firefighters, it's 42. But in a handful of jurisdictions where that governing body has decided that they don't want to go for it, it can be as high as 48. It could be as high as 56, again, at that federal standard. There's a letter in opposition from the city of Cumberland, which says they actually don't start paying their firefighters overtime until literally they've worked more than 56 hours in a week. So at its core, that's what this bill is. There's another provision in the bill around making sure that firefighters are getting accurate information about their pay rates. That is non-controversial. We worked on a small tweak to that last year, and the bill is introduced just to basically say if you don't get it, there's already existing grievance procedures within contracts that allow for those issues to be resolved, but we just sort of codified that firefighters should be able to ask for fair wage information on their wages and overtime, and they should basically expect a reasonable pay stub that explains everything to them. So I would offer you that's a lot of legal language in that part of the bill that makes this probably a lot longer than it needs to be. But at its fundamental core, this bill is about mandating that every jurisdiction in the state hits that 42-hour threshold, they begin to pay overtime. And I want to just comment a couple of things before I turn it over to the panel, because you're going to hear, and there's opposition testimony from some of our municipal governments, and you're going to hear from the folks at MACO. We often mandate these types of things. They'll say, oh, these should be, very clearly bargained in contracts, and this should be something that should be left up to local jurisdictions to do. Whether you agree or disagree with it, the General Assembly and state government has proactively made those decisions. We did it in the blueprint. We do it for often for police and other emergency responders. The 40-hour threshold also, by the way, is standard for paramedics and EMTs across the state I think almost every jurisdiction. Most police also are at that 40-hour threshold. So we're not sort of doing anything new here. Often the General Assembly makes the decision if we believe it is in the best interest of the state. We can set a standard. There is nothing in law that prevents us from setting those standards. And frankly, I would say that it puts different jurisdictions at a competitive disadvantage. Why would you go work in one jurisdiction when you can cross? Why would you go work in Montgomery County if you can be in Prince George's County and get paid more for that same work schedule, or have a more reasonable work schedule? So at a time when we are facing, shortages and major burnout from our public safety and emergency responders, we know obviously that a work schedule is a huge contribution to burnout. But I will say there's nothing in here that mandates, you will also see testimony from some of the municipal governments that, oh, this is going to require us to turn around and now have to hire another 150 firefighters. There's nothing in this bill that mandates you actually have to change the work schedule or that you have to hire additional folks. It just says if you are going to adhere to this work schedule that would put firefighters at more than 42 hours a week, you just have to pay them overtime. And I will say this impacts the jurisdiction that I represent. It impacts Montgomery County. It's disappointing that our county is one of those jurisdictions that does not provide a 42-hour work week or overtime for more than 42 hours. So again, at its core, this bill is fundamentally just about fairness for our first responders, folks who, higher incidence of cancer, literally every call they get, we don't know whether they're gonna come back or not. The last thing I will say before I turn it over to the panel, this bill passed out of the House last year, 134-1. So again, I know this is new for our committee. That's why this was pre-filed, because we had heard this a couple of years before. So turn it over to the panel. Would urge a favorable report and happy to take questions.
Good afternoon, Madam Chair and members of the committee. My name is Josh Fannin. I'm the president of IEFF Local 964, Baltimore Fire Officers. I'm here today as an emissary for the professional firefighters of Maryland. I'm here in strong support of House Bill 532. I'd like to discuss a few numbers with you today. 42 hours per week, that's the overtime threshold for firefighters this bill would establish, and that is the same number of hours under the Federal Fair Labor Standards Act provided to law enforcement officers across the entire country. Next number is 81.8%. That's the support this bill has among Marylanders. A recent Gonzales poll of 808 likely 2026 voters statewide found 81.8% support overtime for firefighters after 42 hours, creating one fair standard instead of the current patchwork. This support is strong across every demographic and party. Delegate Solomon already gave you this one, 134-1. Last year, the House passed identical legislation at a final tally of 134-1, bipartisan and near unanimous because the inequity is obvious. 10,000, that's how many Maryland professional firefighters rush into danger, provide life-saving care, and protect communities 24/7. Construction workers, delivery drivers, retail staff, and many others receive it after 40 hours a week. In Baltimore, police, paramedics, and EMTs we work alongside with every day can get overtime after 40 hours. Why should firefighters have to work longer? We've tried fixing this through bargaining. Instead, hours stretch on without fair pay. This standard promotes equity and helps retain experienced firefighters our communities need. My final number, 141-0. That's the final vote tally we're striving for before sine die. But first, I urge a favorable report on House Bill 532. This is about fundamental fairness. Thank you, and I welcome any questions.
Madam Chair, Mr. Vice Chair, members of the committee, Katie Nash for the Professional Firefighters of Frederick County. My comments are also endorsed by the Professional Firefighters of Maryland, as HB 532 is their top priority this session. I've been honored to work with my local, since 2019, and for 3 of those 7 years, we've asked the legislature to establish minimum work hours standard. The same administration that is fighting this legislation in the name of collective bargaining tried to take away this right through a county-wide referendum. And in fact, Frederick County spent $200,000 for their campaign against collective bargaining in 2022. The career firefighters had to win not one, but two county-wide referendums to keep this right. Over the years, we've heard some funny math for this bill. In 2024, MACO's testimony was that Frederick County would need to hire an additional 50 firefighters. In 2025, it was 100, and you guessed it, in 2026, we're being told it's 150. Now, we're growing in Frederick County, but we're not growing that fast. And let's set the record straight. This legislation is prospective and doesn't amend existing agreements. This bill doesn't prescribe work schedules, as the good sponsor mentioned, and it doesn't change staffing models. This bill will not hurt recruitment. But what it does do is demand that the county stop overworking our firefighters and pay them fairly. This legislation proposes to shift the true cost of providing public safety back to our budget books and off the backs of our firefighters. 3 years have gone by. Think of all the work that we could have done. We appreciate continued support for this legislation, and we respectfully urge another favorable report for HB 532. Thank you.
Thank you very much to the bill sponsor and to your sponsor panel. We have a question from Delegate Schindler.
Okay, thank you, Madam Chair. Thank you very much, Delegate Solomon, for bringing this to us again this year. So I did have one question. You had mentioned that this bill is prospective. And, you know, I was reading through all the testimony, and some of the opposing testimony mentioned that that it would undermine a relationship with the locals. But aren't you both here representing the locals?
Did you want to go for yours?
I would love to. Yes, that's a great question, and thank you for that question, Delegate. You know, I read the letter, and one of the quotes, I believe, was, I wrote it down because it was so great. It said that this bill is going to undermine the county executive's relationship with the local. Respectfully, I would argue that coordinating a conducted ongoing campaign against this bill, this is the #1 bill that affects firefighter health and safety, that actually hurts your relationship with your firefighters. But that's my opinion. I didn't know if Josh wanted to add anything to that.
I don't know that I could be more eloquent than Katie was here, but the one thing I would say is I feel like we're the only public employees that have to go in and worry about bargaining about our work hours every single time we're at the bargaining table. It would be nice to finally join everybody else and take that off of something we have to worry about and really get down to business.
Thank you.
And again, Delegate, thank you for the question. You know, one of the changes, amendments we made to the bill last year when we brought it in the 25 session was specifically to make it prospective. And I think, again, you know, we're sympathetic to the immediate potential impact to a budget of a municipality. So that's why we said this will not affect currently bargained contracts. This will be prospective going forward. And again, I mean, you know, we mandated what the minimum salary is for a teacher in the state of Maryland. I think there's still plenty of great relationships between local teacher unions and their, you know, and their school boards and their county administration. Thank you.
Thank you, Delegate. Delegate Schmidt.
Thank you, Madam. Thank you, Madam Chair. And thank you for bringing the bill, Delegate. I work very closely with Anne Arundel County firefighters, and they have this constant struggle with staffing. As we know, it's been a glaring concern for them, way below the federal level for a multitude of years. I've been at town halls just in the past few weeks where they've expressed, I don't like to use the word frustration, but extreme discomfort with the staffing at our levels. And the safety we brought up numerous times. Does this pose a concern where we're already below the staffing level that we now fall even further down? And I'm the son-in-law of a 35-year retired firefighter. I understand how they work days out, and some work back-to-back, and some pick up shifts, and you know how they have some flexibility to kind of work things out. My fear is we then put this burden on supervisorial level to say we're not going to allow that any longer. We're going to cut you back, and then they're not able to get the overtime that they've been used to. Or I'm just wondering, like, what are the adverse effects of this to get Anne Arundel County to full staffing and the other jurisdictions? And I know that was a long-winded question.
Yeah, well, and I will defer to the folks here who are, Josh in particular is an expert, much more of an expert on the scheduling, but Anne Arundel already meets this threshold, so we would be good with that. This would not impact them at all. This is more for the jurisdictions that, again, and again, there's nothing around the staffing in those jurisdictions. It's purely and frankly, I think in terms of, to your point about shortages, right? If you are particularly in places where you don't have the staffing levels and you're reliant on much greater levels of overtime, I know I personally would be frustrated that if you're making me work more and I can go to a jurisdiction where I can work that same level of hours but get paid more for it, I'm not going to stay in the jurisdiction that I'm in. But Josh, if you want to talk about in those jurisdictions where this would impact, again, it's not Anne Arundel.
I would say in the context of the bill, I would agree with what Delegate Solomon said, that Anne Arundel, they already work 42-hour work weeks in Anne Arundel, so that wouldn't change. And I don't really want to veer into the staffing issues that Anne Arundel has, because I'm not fully up to speed on those, because I think those are more tied towards the staffing that's recommended by the NFPA and how many crews they have to have. That's something that Joe A. would be better to answer about the specifics over there. But I could say that this House bill would not have any effect on changing staffing or scheduling, because that's something that keeps being brought up by opponents to the bill. It would just simply say that for all the people that you already have that already work there, you're not allowed to work them until 53 hours a week before you start paying them overtime anymore. You have to start paying it at 42 hours a week, and that's state law, and that's the way it is everywhere. And by the way, everybody that does have to work that long already is already being paid straight time, so we're actually talking about a half-time premium, and that's all that we're actually talking about.
So I see multiple benefits to the employee at the end of the day in this bill. It would help them in twofold: help safety and help increase their pay for that delta between the 53 and the 42.
I would agree.
Yeah, thank you.
Thank you. Delegate Fair.
Thank you, Madam Chair. Good to see all of you today, and especially my friends from Frederick, always. I have one question and then kind of like just a generic, like, philosophical question, I think. Is there any consternation from your membership, as I'm reading between the lines of all the testimony, the positive and the people that are supporting this, the people that are in opposition to it, I'm getting the same general feeling as, again, an employer in Frederick County for years and years and years. What I'm reading between the lines is, if we pass this, chiefs are going to be forced to, instead of paying overtime, hire new people and cut hours of people who are currently employed. Is there any consternation from any of the unions, any of the firefighters, that they could end up actually working less hours because we pass this?
I think the easiest way to answer that is the reason that this is the priority legislation from the professional firefighters of Maryland is because at our convention, our biannual convention in 2023, this as a top priority was brought to the convention floor and it passed unanimously. And so that was no dissenting vote. And since this topic has come out as a priority that people are discussing around firehouse kitchen tables, I've never heard anyone ever say, I don't want to work a reasonable number of hours before getting overtime. I'd rather not get the extra premium that everybody else gets. I've never heard that, no.
Okay, no, that's good. That's, again, just, and then, I mean, philosophically, and I guess this is to the bill sponsor, Delegate, I mean, philosophically, this seems to come down to one really key decision, is, are we at the state comfortable with the idea that we are going to put a mandate onto the counties and say, listen, we're doing this, and we all acknowledge this is going to cost potentially significant funding to be able to make all of this work. Is that fair?
Yeah, no, I think that's, to a certain degree, the crux of the issue here, Delegate, and I appreciate the question. And again, I mean, this is a jurisdiction this impacts a jurisdiction that I live in, and it's hard for me to, we work really closely with our professionals. We have volunteers that obviously would not be covered by this, but we spend a lot of time. We had my son's 4th birthday party at our local volunteer local firehouse that is also staffed by professionals as well. And it's hard to say you shouldn't be getting overtime for fair hours worked. Just to go back to your original question as well,
please.
I think the cognitive dissonance that I see in the testimony from some of the opposition folks is if your concern is the budget, and so if paying your firefighters more overtime is going to cost you $3 million a year, I don't understand why the alternative that you would say is somehow better is going to be to go out and then hire 100 or 150, whatever the number is, that's going to cost you $20 million, right? If it is about budget pressure and budget pressure alone, you would just keep the work schedules the same. And again, in the vast majority of jurisdictions in the state, it is just that 42-hour threshold. So
thank you. No, I appreciate you setting kind of that bar for us to understand this issue. So thank you so much for bringing the bill forward. Thank you, Mr. Chair.
You're welcome. Any further questions for the sponsor panel? I don't see any. Delegate Solomon, we have Eden Durbin showed up, but she signed up as you.
I was going to say that's my chief of staff. Yeah.
Okay. All right. All right. We do have one more favorable witness. I'll call Tony Perez.
Thank you. Pleasure working with you. Yeah.
Good afternoon, Chair and Vice Chair and members of the committee. Thank you for giving me the opportunity to come before you and testify. I'm Tony Perez of LA Perez Consulting. I'm representing the Prince George's County Professional Firefighters Union, Local 1619. I'll try not to be redundant. I think a lot of things were said by our committee, but I will tell you, Prince George's has operated under a 42-hour work week standard for roughly for 4 decades, about 40 years approximately. The fire department still responds, still recruits, still retains, and still balances its budget. If Prince George's County can do this year after year, administration after administration, then the rest of the state can do it as well. A 42-hour overtime rule does not weaken fire service, it strengthens it. It promotes fairness, transparency, and sustainability. It will also help to prevent excessive mandatory overtime, chronic fatigue, and missed family time, which is a major issue for firefighters. Firefighters are not asking for a special treatment. This bill only mandates overtime for firefighters over 42 hours. No different than individuals who work in offices who get overtime over 40 hours. Furthermore, this bill does not mandate a change in schedule. This is about fair pay. Prince George's County has shown it can be done. Now we respectfully request the state take the lead, and we ask for a favorable report.
Thank you. Do we have any questions for Mr. Perez? Seeing none, thank you for your testimony, sir.
Thank you.
We do have an unfavorable panel. Let me call Carrington Anderson and my chief, Tom Coe.
Mr. Vice Chair, members of the committee, thank you for the opportunity to speak with you today in opposition to House Bill 532. My name is Tom Coe, and I serve as the fire chief in Frederick County, and I'm here today on behalf of County Executive Jessica Fitzwater. Today in Frederick County, our firefighters assigned to fire stations average a 48-hour work week, which involves a rotating schedule of 24 hours on, 48 hours off, with a 5-day break every 3 weeks. House Bill 532 would move our firefighters and EMS personnel to a 42-hour work week. There are 2 ways to accomplish the requirements set forth in House Bill 532. Fire departments can pay overtime to employees when they work in excess of 42 hours, or they could move to a different shift configuration. In Frederick County, if the overtime option equates to at least $4 million in increased personnel costs, while the reconfiguration to a 4-shift deployment would require the hiring of 151 firefighters at a cost of at least $17 million and take no less than 2 years to implement. Frederick County is committed to the health and safety of our first responders and has worked diligently to move to meet national staffing standards. The passage of House Bill 532 and the associated financial cost will significantly delay the implementation of the national standard 4-person staffing model and other critical staffing initiatives in our rapidly growing county, thus reducing the safety to our firefighters and the public they serve. Additionally, many departments do not have the number of specialized positions like paramedics, hazmat specialists, technical rescue specialists, and apparatus drivers to move to a 4-shift deployment, meaning that if that's the route a jurisdiction takes, the legislation could negatively impact the number of staffed apparatus or result in frequent mandatory holdovers to maintain minimum staffing levels. For the reasons I shared, I respectfully request that the committee provide an unfavorable report on House Bill 532.
Thank you, Mr. Vice Chair, members of the committee. My name is Carrington Anderson here on behalf of the Maryland Association of Counties in respectful opposition of House Bill 532. You have my written testimony in front of you. The county's concern with this bill is that this does undermine local collective bargaining authority over overtime. It's an unfunded mandate, and it is going to cost impacted counties millions of dollars. Puts local jurisdictions in an unsustainable position long time, which is why firefighters do have this partial exemption federally. It's because of their unique shifts. They don't fit into a regular 42-hour work week for some. That's why you hear it's uncommon to have a 24-hour on, 48 off, 24-hour on. With that shift alone, you're automatically paying overtime under this bill. Additionally, what this bill doesn't take into account is for the counties that are doing this, the ones that did negotiate this locally, they are negotiating to offset different benefits. This bill creates a statewide standard, which then gives the counties who aren't doing this, there's nothing to negotiate as far as that. So there really are a lot of significant concerns for counties on this bill. So we'd respectfully ask for an unfavorable report. Thank you.
Thank you for your testimony. Delegate Fair.
Thank you, Mr. Chair, and thank you both. So we're all kind of getting, this new committee is kind of getting caught up on these issues, and so I appreciate your time to help educate and kind of illuminate. I'm intrigued by this 24-hour, 48-hour off scheduling model, but something that you said in your testimony, Chief Coe, was you talked about these need for these specialties that exist inside of that. I think for a lot of us, we think of an employment record. We think 8-hour work shift, you go home, you get back there, 40 hours, you know, why is this so complicated? Can you kind of help explain a little bit more about why there's a 24 on, 48-hour off, and then why, what's the deal with the specialty areas? Like, how does that complicate and frustrate the process for you?
Absolutely, and I appreciate the question. There's actually lots of different shift configurations across the state that are used to meet the normal work hours that are agreed upon at the local jurisdictions. In Frederick, we have a 48-hour work week that's averaged out using the 24/48 with what we call a Kelly day, or a day off every 3 weeks to bring down our average work hours. That schedule's similar in Howard and Montgomery counties. There's several places that work a 24-hour on, 72-hour off rotation, which is a 42-hour work week. Similarly, places like Baltimore County work 2 10-hour days, 2 14-hour nights, then have 4 days off. So there's lots of different shift configurations to get to where you're going, but your shift configuration drives the number of employees that you need to fill the mandatory minimum staffing that the jurisdiction's designed. The fire services and all hazards response agencies. So we go to fires, we go to emergency medical services calls, we go to hazardous materials responses, all sorts of rescue and extrication events. And there is no such thing as just a standard firefighter. Firefighters specialize in lots of different things to serve the community they work in. We have folks that are specially trained to drive some of our larger aerial apparatus that everyone likes to refer to as bend in the middle, right? We have folks that enjoy water rescue or rope rescue, hazardous materials response. But every jurisdiction has a minimum number of responders in those specialty spots to serve their community 24 hours a day, 7 days a week. In Frederick County, our specialty position numbers and counts currently are built around a 3-shift rotation. So if our selected model or answer to this legislation was to move to a 4-shift model to bring down the number of hours worked weekly, that we would have a shortage of those specialty positions to adequately serve our community. The end net result of that could be, unfortunately, mandatory holdovers if no one's willing to work to fill those spots, thus decreasing workplace satisfaction, decreasing morale, and cause general organizational issues. So it takes time to build up those specialty positions. It takes time to build up the staff commensurate to fill that additional shift requirement, understanding that the legislation doesn't require the shift, but it is a mechanism to get to what the legislation is looking for.
And what is and last question, just what is a mandatory holdover?
A mandatory holdover is when we don't have the minimum staffing needed to meet the next day's allotment, and someone's not allowed to go home. They actually have to stay against their desire to provide service to their community. And unfortunately, that's something that our industry deals with occasionally. It's not our wish to be there, but that's where we occasionally land.
Gotcha. Thank you. Thank you, Chief. Thank you, Mr. Chair. Madam Chair. Switched again on.
Keeping you on your toes. Delegate Stewart.
Thank you, Madam Chair. I just have a really quick one. Chief Coe, could you send us the math behind the $4 million, $17 million number so we can look at that? Right, thanks.
Yes.
Delegate Tomlinson.
Thank you, Madam Chair. I have so obviously there's a, like Delegate Stewart just asked about the money, but about the actual position. So you're saying that for Frederick, you need to hire 151 firefighters. So my question is, I know you're Frederick, but you're very familiar with Carroll County, and we have a brand new fire and EMS department, and the challenges that our county faced kind of getting that started up. And I think we're in a good place now, but it took many years. But I feel like one of the problems we had in Carroll was just trying to get to build up our workforce. So this is just Frederick, so obviously it's going to impact several more counties than just Frederick. And so I don't know how many more additional firefighters we're talking we need to be hired. Are there even enough people out there or going through the academy or enough interest to even hire that many firefighters?
So there is interest in fire service work, but the interest isn't nearly what it was 5 years ago. So we're challenged with recruitment initiatives. All the jurisdictions in the state are really vying for the same pool of people. So if this legislation passes, and if multiple jurisdictions elect to go to a 4-shift model to bring their average hour work week down to 42, there'll be an increase in labor demand, but no increase in the people to fill those spots. So today in Frederick, we have a recruit class that started 2 weeks ago, and we really draw from much more than even just the East Coast. We have folks from northern Pennsylvania, from New York, down to the Carolinas. We've hired as far away as Minnesota and Colorado to come work in Frederick County. So it would absolutely be a challenge to fill all the vacancies if all of the jurisdictions went to a 4-shift model.
So even if money wasn't a problem, it would still present
There'd be an implementation timeline issue.
Yeah. Okay. Thank you. Thank you, Madam Chair.
Absolutely. Thank you, Delegate Wu. I want to just acknowledge that Delegate Wu, he saw me ask if there was any more questions, getting to wind down, he waved his hand. So I just want to say that would be helpful in the future for other people.
Madam Chair, I'm a good student, right? Thank you. I hear you. Thank you. I hear you talk about we actually got a lot of applications from outside of state. That's kind of good news, right? So what really drew people applying to Maryland?
I think what really draws people to apply in Maryland is a lot of states that surround us do not have county-based fire service entities. They're smaller townships, smaller municipalities. So there's a lot to be said for a large municipality, a city, or a county-based fire service, and the opportunities that it presents prospective employees. And I think that's what draws a lot of people to Maryland.
What does opportunity mean here? Is it job opportunities, or is the work environment is better, or job security?
Could you repeat the question?
You said there are job opportunities, right?
Yeah, so the job opportunities, meaning that they have a palette of different opportunities when they come to a larger county-based or large municipality fire service. So opportunities like a technical rescue team that might not exist in a small municipality, opportunities like a hazardous materials team or a paramedic educational program, those things exist in the larger jurisdictions and how a lot of Maryland fire departments are constructed versus what's in other states.
I see not every job is equal, even the fire department.
Correct.
I say, thank you.
Yes, sir.
Thank you very much, Delegate. Okay, seeing no more questions for this panel, this concludes the bill hearing for HB 532. Thank you all for your testimony.
Thank you.
Have a great day. We will move to our last bill of the day, Delegate Pastor, HB 612. And Delegate Pastor, I have on your first panel, Ann Pack, Yvonne Briley Wilson. And then on panel 2, Mr. Henry Gregg, or Dr. Henry Gregg, excuse me, Michael Gray and Dr. Stephen Sturr.
Madam Chair, would you mind if Dr. Gregory goes in the first panel? Because
Sure.
he has to leave.
I completely understand.
Thank you.
Yes.
Appreciate that.
Okay.
I'm sort of malfunctioning.
No worries. We have time.
Greetings, Chair Wells and Vice Chair Kerr, and members of the Government, Labor, and Elections Committee. I am Delegate Cheryl Pasteur, and I am here about House Bill 612. Again, I come before you and the members of GLE to speak about a program which has already proven to be an asset to the lives and growth of those who are behind the prison walls and beyond. These incarcerated counselors have grown and shown healing of their own pain to heal and to be a part of the solution for the growth and healing of other incarcerated individuals. You will hear firsthand why you are going to see the kinds of things, the depths of the things that they have done. But I'm going to tell you first about the things that I have seen and the things that I have heard, and why I think that this is a program that is invaluable both inside the walls and outside of the walls. You will hear why I've become so excited about the possibility of this program growing and making a difference. The purpose of the bill is to extend the support for the education and workforce skills training programs provided by the Maryland Department of Labor. The Certified Peer Recovery Specialist Training Program, or CPRS, equips incarcerated individuals with the knowledge, certification, and lived experience-based skills needed to support those struggling with substance use disorders. These men and women get professional training and certification for in-facility recovery support and post-release employment in behavioral health and community recovery services. This Maryland Labor Correctional Education's current program is primarily supported by the Maryland Office of Overdose Response and grants, which are appreciated but needed and not enough to sustain growth. Beyond drug recovery counseling, these specialists have served in instances to ease tensions in the prisons. They are role models known as the Purple Shirts. Admittedly, both the Department of Labor primarily and the Department of Corrections rely on grants to continue this program. They need funding for 2 additional trainers who will also collect data, monitor program quality and needs, and work with external partners. This program is needed for safety and mental health supports within the walls and levied by those who have the lived experiences. So many people I have met expressed how much they miss the emotional, interpersonal, and intrapersonal support they received from the purple shirts while incarcerated, which is why I am sponsoring this bill for those in and outside. The counselors, many on the staff of Labor and Corrections, and those from whom you will hear today, support the need for and worth of this program. The advocates and I are open to amendments if deemed needed. I am asking that this committee give this bill a favorable vote. Thank you.
Good afternoon, Chair Wells, Vice Chair Kerr, and the committee members of Government, Labor, and Elections Committee. I am Yvonne Bradley Wilson, the Correctional Ombudsman, and I am here to offer our support for HB 612. I think it's most appropriate to refer to those behind the walls and these roles as counselors, because the concept of CPRS program is to allow those behind the wall to cultivate transformative change in one another by utilizing their own lived experience, proper and intensive training, and the camaraderie that is established as a result of the incarcerated individuals working towards their common goals and the commitment to improve themselves, whether they are being released from behind the wall or not. An example of this program is currently operating within Jessup Correctional Institute, as well as other DPSCS facilities, where the OCO staff has had the opportunity on numerous occasions to interact, support, and encourage incarcerated individuals participating in the program. Their experiences with the program is not only beneficial to the lives of incarcerated individuals they mentor and support daily, but those individuals that wear those purple shirts, they too benefit. This is especially true for incarcerated individuals serving longer or even life sentences. I have been directly told by numerous of these individuals that this program provides a sense of purpose, and it also allows them the opportunity to help others in their successful recovery, cultivating professional skills and commitment to serve and benefit others. I ask that you grant a favorable report codifying the legacy of this program and those who benefit from it. Thank you.
Thank you. I am Ann Peck. I am co-founder and director of advocacy for Prepare, but more importantly, I'm a graduate of the 2020 CPRS program at MCIW. And that program was the first time we had ever had peers behind the walls. We serve each other within the community as peers. So once we're trained, we become peers for other incarcerated individuals and provide a service that would otherwise be gone. Once we come home, it provides living wage work. I have a CPRS certification. I'm now a registered peer supervisor, and I'm a director of a nonprofit. But what hasn't been mentioned is the peer program provides gender equity, because it is the only workforce program that provides a real-world certification at MCIW to the women. A lot of the other programs, ASE, NCCER, they require you to build a shop and buy some tools, and that isn't going to happen for a population of 600 women. This requires trainers and books, and it provides a real certification that has value and living wage work in the community. If this program disappears, so does the workforce opportunity for every woman behind the walls in Maryland. This is a tiny fiscal note, and this program is currently teetering on grant funding that we all know is threatened in this environment. As someone who works in nonprofits, I'm keenly aware of how year-to-year grant funding can easily collapse. What we're asking for is for the state to make a commitment to peer services behind the walls being available, a commitment to incarcerated individuals coming home to living wage work, and a commitment to offering women opportunity to train behind the walls as the men already have. I urge a favorable report for all these reasons.
May he go ahead and start.
Dr. Henry Gregory. I've had the privilege of working with people incarcerated in recovery for quite some time. And I'm very much in favor of this bill for two reasons. One, it assists in the healing that many people are experiencing with incarceration. As has been said, it helps people fulfill their sense of purpose, to find some direction, to find meaning in the traumas they've been through and the experiences they've had, and utilize them for the healing that happens in the communities. So when people are trained as peers, they become a bridge between professionals and the clients with that lived experience. Excuse my language, academic training has its place, but only if it can validate lived experience. Only if it helps people to get clear about who they are, what they bring to the table, and what it takes to not only survive, but to thrive. In training peers for the last 15, 20 years, it's been just magnificent to see the effect that they have in connecting with clients in programs and on the streets. Because they speak the same language, they've had some of the same experience, many of them know each other, and it's just a validating connection that everybody benefits from. So I'm definitely in support of Bill 612.
Thank you. Thank you so much, Delegate Pastor, for the bill, and to your sponsor panel. Ms. Pack, could you talk a little bit more about, because you mentioned, and it piqued my interest, but you mentioned in your remarks about how it's one of the few or only programs that allow women behind the wall to get a certification that can translate to a good, lucrative, financially lucrative job once they leave. So can you just explain a little bit more about, I guess, the absence of those programs?
Absolutely. The biggest problem is that there are about 15,000 men and there's 600 women. And a lot of the vocational programs that exist in Maryland are things like auto repair and auto detailing and construction trades. And that requires a shop facility to be built, it requires tools to be bought, and it requires you to have a consistent supply of people to go through that program to justify that expense. Because the women's population is so small, we never received any of those services. We got office technology on 20-year-old computers, and we got Flagger one-day certifications, which is dead-end minimum wage work. And that was what we had. We have MCE, Maryland Correctional Enterprises. We have jobs like maintenance that you can do on the compound that might give you a labor certification, but it's not giving you a real-world certification, so it means nothing to an employer. Peer services changed the game. I came home, I had an actual certification with a certificate number on the MABPCB site. You can look up my name, and you can see that I am a certified peer recovery specialist. It gave me job opportunities that I would never have had.
Thank you. No, I was very surprised to hear this. So I do appreciate you talking a little bit more about some of those, the absence of, I think, the resources that our women behind the wall need. Just seeing if there's any other questions from the committee. I do not see any further questions from this committee. So, for this panel. So we will move to our next panel of individuals. Thank you to those that testified just now. And I know we just heard from Dr. Gregory. So I have Michael Gray and I have Dr. Stephen Sturr. There are a few other individuals that are not listed on your second panel, but they are listed here as favorable. I have Aaron Wright and Terry Speaks and Desmond Perry. I think may have.
Excuse me, Chairman, you have Michelle Kennedy Quadio. I received an email that
I do have you, excuse me, you're on the, yep. I have you listed as informational, or? Yes, absolutely, but I do have you listed. So once this crew of folks finish, I'll make sure I call you. Thank you for, it has been a long day, and I've watched you be patient, so thank you for being continued patience. I'll let you guys decide.
I guess I drew the short straw. Good afternoon, Madam Chair and committee members. Thankful for the opportunity to be here. My name is Aaron Wright. I'm the General Program Manager for Voices of Hope. First, I just want to kind of say I am a certified peer recovery specialist, registered peer supervisor, community health worker, recovery coach professional facilitator. All of that means is that someone helped me out of a hellish existence and I'm willing to turn around and help the next person. With that being said, I had a lot of challenges because I was a heroin addict for 23 years. And as of January 2nd, 2015, I've found recovery. So a lot of the challenges in the workforce development force, I had to come up with a lot of reasons on a Friday night that my construction crew would say, hey, listen, you want to go out for drinks? And I'm like, can't. I got to walk my grandmom's cat. You know how it is with my gym schedule. I had to come up with all these things, right? Because I'm just going to sit there and tell you that, yes, I was formerly incarcerated. And I'm just going to throw a number out there and bet my annual salary on it that at least 50% of the incarcerated individuals in our judicial system today have a substance use disorder or mental health, right? With that being said, I found myself not going to construction crew, and 3 of us have actually developed the biggest recovery community organization in this great state of Maryland called Voices of Hope. 68 of our employees, or 65 out of the 68, are individuals in recovery from substance use or mental health. And then 80% of those are formerly incarcerated. Now, the challenges with this is when we hire certified peer recovery specialists, they have to go through the curriculum and they're learning to do the job while they're learning what the job is. Having this in the justice system will not only find meaning and purpose for the individuals that have substance use and mental health disorder, but will also help the behavioral health infrastructure when they get out that can go right into jobs like you formerly heard. So I'm in fully support of HB 612. Thank you so much for your time.
Good afternoon, Madam Chair, members of the committee. My name is Michael Gray. I'm with the National Alliance on Mental Illness, NAMI Maryland, the state organization of NAMI. And we're here today to support this bill because NAMI offers a lot of free community-based services to the public, including support groups for people who are in recovery and who are living with mental health conditions. And, you know, we're a big believer in the old story about the man who falls in the hole, you know, the story about the man who falls in the deep hole. First person walks by, puts down a ladder, it's not tall enough, so can't get out. The second person throws down a rope, and he can't hold his weight. The third person is an old friend. He recognizes his voice, and he jumps down in the hole, and he said, why'd you join me in the hole? He said, because I've been in this hole before, and I know how to get out. And that's exactly what certified peer recovery specialists can do. And allowing this avenue, as you heard from the sponsor panel, to provide workforce development, yes. Job opportunities, yes. But also the treatment from a piece of a continuum of care to go hand in hand with medical treatment, but also just having that experience, that firsthand knowledge of knowing what it's like to be in that place and how you yourself came out of it, re-entered into the community, and stayed out through support from your peers. That's what this bill is all about, and that's why NAMI supports it. Thank you for your time.
Good evening. My name is Terry Speaks. I'm also a peer recovery specialist. I'm also the leadership development organizer for Alpha Justice. I'm also an advocate for youth. I go to court and mentor youth. If it wasn't for the peer recovery program that I went through when I came out of prison, I probably wouldn't be sitting right here because it taught me ethics. It taught me about my trauma, depression, all these different things that I discovered when I took this course and became certified. And I know for a lot of the women and the brothers and sisters that's still inside of prison, having a peer that looks like them, been through some of the same situations as them, to be able to sit there and listen to their problems or whatever they're going through is key, because a lot of times they may not go to the psychology or whatever the case might be because of certain stigmas. But if they have somebody that they know went through a certified program that can actually help them and listen to them without judging them, it's a game changer. This gave me an opportunity to sit before y'all to earn a living, or above a living wage that I normally wouldn't have had I not went through this course. So House Bill 6112 is a game changer, and I really hope that my example, everybody else's example, can show y'all that this program is needed to rehabilitate, to help lower the recidivism rate within the population of people when they come out, and provide them with the opportunity to earn a living wage. I know it's not easy. I know y'all have budgets and different things like that, but I'm asking y'all to take a chance. If you're gonna gamble, gamble on this program because it's worth it. And I urge a favorable reply. Thank you.
Good afternoon, Madam Chairwoman and members of the committee. My name is Dr. Stephen Stewart, and I'm here to testify in favor of this bill. Please accept my wholehearted support of HB 612, sponsored by Delegate Pastor and others. Currently, I'm a chair of the Governor's Prison Education Delivery System Reform Commission. And I've been working very closely with Delegate Pastor during the past year on issues related to education of incarcerated individuals. Because the commission had been advised by the governor not to get directly involved with sponsoring bills, my testimony here does not represent the opinion of the commission per se. The commission, however, has created more than 15 recommendations to the governor and legislature, some of which are reflected in HB 612. My support is based on more than 50 years of service working in criminal justice as a teacher, educational and correctional administrator in Maryland, Federal Bureau of Prisons, researcher and professor in Maryland. As a correctional education administrator, I saw how effectively we were able to train and utilize incarcerated high school graduates as tutors to assist in the academic classroom. Many of those who worked as tutors were released and continued to work with other formerly incarcerated individuals who had not completed high school. We provided classroom space in some state office buildings and never encountered any problems. More recently, I have observed how effective peer recovery specialists have been in one of the Jessup institutions. The warden testified that they were effective not only in counseling their peers, but also in assisting security staff in cooling down tense situations. Many of them have been released and are working in similar positions in the community. In summary, my professional experience and research have taught me the value that incarcerated and formerly incarcerated individuals can have in their rehabilitative process. Many of them have become positive forces who communicate effectively with their peers. Of course, formerly incarcerated individuals should be subjected to the same screening and investigation used to hire anybody who works in corrections. I believe most correctional officials would be very supportive of the employment of formerly incarcerated individuals inside their facilities. Thank you for your time.
Thank you very much. All right. Okay, thank you. Thank all of you for your testimony and for your patience as well. That that does not conclude the bill hearing, but I wanted just to make for the record that Desmond Perry was signed up to testify virtually, but is unable to join us. And we will hear our informational witness, Ms. Michelle
Kennedy
Quadio. Thank you.
I've never been to Austin, Texas. But I've been here today. Anyway, Madam Chair and everybody who's listened and learned, you know, I get to sit in and listen to all of these things and get to assess your personality types. By the way, so I signed up as informational because I'm such a detailed-oriented person that I won't give a favorable or not favorable unless I read and am more brief. So after this, can I change my position to favorable? Okay, so I'll change it to favorable. Yay. Here's what I have to say about that. I'm vice president of A Mother's Cry. You can look us up on amotherscry.org. The president, Jay Messina Green, sends her greetings. We're both mothers of people that have been at ECI, a hard place to recruit for correctional officers. My son has been attending NA meetings, Narcotics Anonymous meetings, for several years. He's become a leader, not a certified peer specialist. But I will say that in doing my quick research, 70%, and I believe it's higher, of our prison population suffers from addiction. 30% of that are dual addicted. I have a son who's dual addicted. That means you've got depression, you've got, ADD and all of these things. Yet only 3% of the population gets the mental health or the addiction services that they require. So for that reason, on impact, positive impact on individuals in the prison, I support it. Also, we have written testimony from John Griffin, who was recently released within the year from ECI. He was there for 14 and a half years. As you know, the challenges with ECI, the most populated prison, is one of recruiting sufficient correctional officers. Though the information I would provide is you have to have sufficient correctional officers for admittance of people coming from the outside. Additionally, you need to have volunteer activity coordinators, whether it's for religious programs or anybody coming into the institution, to make sure that you have the proper meeting space and these sort of things. How do I know this? Because we actually have educators that try to enter ECI, and there's a lot of barriers. So I could go on, but I won't. I think it's a very positive move. I would just ask the DBCS do a great job in recruiting correctional officers. We're 2,500 short. That's the bottom line, especially at ECI. So I believe in these programs, but I'm the type that looks at impact on incarcerated individuals to see if we're being successful and if we're pulling all of the, appropriate factors together. So thank you for this time. And I give a favorable review for the record. And I've never been to Austin, and if I had been, I probably would remember it. Thank you.
Thank you so much, Ms. Claudio. And seeing no questions from the committee, I want to thank all of you as well for your patience, for being here until the very end, and for your testimony as well. With that, that concludes our bill hearing for HB 6112. I do want to just flag for the committee that we have scheduled for tomorrow a vote session at 1 p.m. More details to follow. So just wanted to make that known to you all as well as to the public. With that, this adjourns our bill hearings for today. Thank you.